May I please?
Yes.
I just to one for listing, my lord. May I pray for tomorrow? May I please, your lordship? I beg to mention item number 13, lordship. What a fictional.
30.
13,
13.
on the daily list. 13. This time, my lord, conducting counsel, my lord, Viraspa is some difficulty, lordship. So I pray for password for that. I have taken consent from the other side.
This item, what is this matter about?
Lordship, my lord, this is extrajudicial killing, lordship.
That's right.
So, last occasion, my lord, some
Just
report
wait.
was called for, lordship.
Just wait for some time. Let me have the record. Next.
May I please, your lordship? I beg to mention item number 4. Because the conducting counsel father is admitted in medical, lordship.
Okay.
So,
Item 4. Both
Yes.
sides are represented on the claim made by and counsel for petitioner. List after. It goes after 2 weeks.
lordship.
Mr. Sharma, in this case, we had called for the case diaries of 2 cases. Item number 13. As per your record, have you received it? Can you tell us? One is Maibong PS case number 6 of 2018. Another is Maibong PS case number 2 of 2018. Just check up. This is not foreigners matter. This is extrajudicial killing. Item 13. Just wait. Let the matter be called because the government, Mr. Nath was appearing. We'll not adjourn it right now. Renew the prayer when the matter is called.
Lordship. Hello, lordship.
Daily list item 1 for motion.
May I please, sir? Lordship, kindly see the order dated 22/1/25, lordship.
You have to make submissions on maintainability.
Yes, lordship. On the ground of delay, lordship. Lordship, we have mentioned the ground of delay in para 12, lordship. Apart from that, lordship, this is the this both
Just
is
now.
on merits, lordship. So this may be hard on merit.
Para number?
12, lordship. This 13, para 12.
This is something which is not acceptable.
4 years, 4 months, 22.
That's
20
okay,
days
but the
delay.
ground taken, the first line itself doesn't inspire confidence. You're not saying anywhere what steps did you take to get the information about your case. It is very easy to say that the lawyer did not inform us. What step did you take? Does the client have no duty? You can show us any case law on the point that it is not the client's duty to get the information about his case or her case. You don't file a complaint against the lawyer. You don't give him any notice. You don't seek any explanation from him.
But the second part of my delay, ground of delay, lordship. After a couple of months, lordship, the engaged counsel informed that thereafter he entrusted one lady, lordship. He did not file before the Honorable High Court, lordship. Second part may be seen, lordship. This is the ground, lordship.
Correct. And who is this lady?
Lordship, we have mentioned her name, lordship.
We understand she is very famous, just like Sunil Gavaskar of our times. Once we read the name Pretty, we must understand that she is a famous lady. I don't know many star names. Sunil Gavaskar is one I would know. Kapil Dev I would know. Is she something like that?
No, Lordship. I am praying for Lordship. The case on merit, this is a good case.
But you said you have to
This
tell
part,
us.
Lordship,
It's not so easy.
Lordship, since the issue is a citizenship of a person, Lordship, this matter may be considered, Lordship. This delay may be considered.
You see, your case is just like the APSC scam. You pay this lady 25,000 for filing a case. You don't even say that she's a advocate. You give it to a third party.
Yes, sir.
How is the court convinced for the absence of delay on your part? You are as culpable as the lady who took 25,000 from you.
Well, Lordship, in village level, this petition is still going on. They entrusted some persons to file cases.
I don't know.
can't-
Historically, you see, there are many people who spend money just like that. People have money, they spend it.
Matter may be hard on merit, Lordship. It's a good case on merit, Lordship.
You're not satisfied. Not even a single line anywhere inspires confidence. She came to know that the lady did not file a case. Then she expressed her displeasure. Then the ladies took a couple of months to return. You don't know anything. Couple of months, maybe 2 months, couple of months, maybe 20 months. We don't know.
Considering the issue is the citizenship, Lordship, this part may be considered, Lordship.
No,
And Lordship, allow me to pursue on merit, Lordship. Kindly allow me a few minutes, Lordship. I will convince you list on merit, Lordship.
no. Once you oust yourself from on the point of limitation, either you give a satisfactory reply to that, otherwise this petition would not be maintainable on ground of delay. 5 years delay without any explanation is not to be condoned like that. You want to satisfy on merit, you show us something on merit. These things won't do.
Diary admission report. General diary.
Then we'll dismiss it if you have nothing more to add.
Then Lordship, kindly allow me another chance, Lordship. We are going to file a additional affidavit, Lordship, in this
We
regard.
gave you an opportunity, but you are not taking it. Okay. We pursuant to order dated 22 January 2025, by which the learned counsel for the petitioner was directed to address the court on the maintainability of the writ petition on the ground of delay, Mr. A.T. Sarkar, learned counsel for the petitioner, has referred to the statement made in paragraph 12 of the writ petition. Full stop. Not even a single statement made in the in para 12 of the writ petition inspires confidence of the court as to the correctness of the allegations made therein. Full stop. Next panel. All the just refer the names, Ms. A. Verma, learned standing counsel for FT matters, Ms. T. Barwa, learned standing counsel for the ECI, Mr. T. Sharma, learned senior government, additional senior government advocate for the state, and Ms. A. Gayan, learned CGC for the Union of India are present. Next panel. On the prayer made by the learned counsel for the petitioner, the matter stands adjourned for
2 weeks.
2 weeks to enable him to obtain instructions and take necessary steps in the matter. Full stop. Matter stands adjourned today, based after 2 weeks.
All right.
Item 2,
My lord, we have challenged the improved order, that is page 77, my lord. Lordship would see the relevant portion of the discussion, page 79.
Just a moment. LCR is not received.
LCR has not received, my lord, though it was called for. But my lord, I have a good case on merit. So my lord, my prayer would be to grant him bail till receipt of the LCR, because I will satisfy your lordships on those points.
Yes, please show us which
Kindly see
paragraph you're
page,
referring to.
page 79, my lord.
79.
Sorry, page 78. First, kindly see page 78. Para 5. Everyone Rafiqul Islam, who is the
Just a
proceeding.
moment. Just a moment. Yes.
Page
Yes.
78, para 5, lordship, kindly see.
Yes.
Jadwal 1, Rafiqul Islam, alias Rafiqul Islam, the proceeding filed his evidence on affidavit, and thereafter he did not depose before the tribunal. In his affidavit, he stated that his father's name was Abdul Hamid, son of Abdul Hasim, and he was a resident of Mouza, Rangagara under Samugri LSE, and he also stated that his father's name was enlisted in the voter list for the year 1965 of village Kodomguri Gaon. The proceeding also stated that his paternal uncle Hamid Ali, son of Abdul Hamid's name was enlisted in the voter list for the year 1966 of village Kodomguri Gaon, and the proceeding also stated that he was born at the aforesaid village, and thereafter he had been living at Moamari Gaon, and Government Gaubura Guljar Hussain of the aforesaid village issued a certificate in favor of him. The proceeding also stated that at present he was been living in village Bamuni Pathar Gaon since 15 years, and the Gaubura Sri Dhoniram Gunju of the aforesaid village issued a certificate in favor of him. The proceeding stated that Election Commission of India issued a voter identity card in favor of him. Now, Lordship would see first, the learned tribunal said that he did not depose before the tribunal in his affidavit. What he stated. Now, Lordship, kindly see his statement. He actually deposed before the tribunal. Kindly see his statement, page 53, man. Page 53. This is his statement, my lord, before the tribunal. And the tribunal, the particular portion, Lordship may kindly see, page 56. Here, there is the seal of the tribunal as well as signature of ED cum accountant. So, he filed this.
Mr. Mahmood, this won't take us anywhere. You come to page 58.
Yes.
50 is not a. It's just a verification.
58, there are exhibits, my lord. Kindly see to 58
I
top.
understand, but Mr. Mahmood, we have to read the entire evidence.
Yes.
In this evidence, where is the evidence?
Evidence, Lordship, that Lordship kindly.
Where is the verified statement made on oath? Which statement is true to his knowledge? Which statement is true to the record? And where does it appear for cross-examination?
Actually, my lord, that if your lordship is on that, I have no answer because I cannot go beyond record. But thing is this, my lord, when the exhibits have been exhibited, numbered, and there is no rebuttal on the part of other side, and that is a question, my lord.
Can there be a rebuttal without an evidence?
Evidence, my lord, may kindly say page 56, evidence, Hapotnama, that is on oath. Page 56
I
on
don't know,
oath.
please read 58. I have read it.
Yes, 50.
My understanding may be wrong, plus convince me that this is an affidavit.
Let me continue, your lordship. It is not from page 56, my lord.
Yes, we understand. We are on the affidavit part at page 58.
58. 58, my lord, it is, he says that এই গোচৰত নিম্ন বৰ্ণিত নথিসমূহ প্ৰদৰ্শন কৰিলো। প্ৰদৰ্শক এক মোৰ পিতৃ আব্দুল হামিদৰ নামে থকা 1965 চনৰ ভোটাৰ তালিকাৰ কপি। 2 চামগুৰি থানাৰ অন্তৰ্গত মোৱামাৰী গাঁৱৰ চৰকাৰী গাঁওবুঢ়াই দিয়া চৰকাৰী গাঁওবুঢ়াৰ প্ৰমাণপত্ৰ। প্ৰদৰ্শক 3 জখলাবন্ধা থানাৰ অন্তৰ্গত বামুণী পথাৰ গাঁৱৰ চৰকাৰী গাঁওবুঢ়াই দিয়া প্ৰমাণপত্ৰ। প্ৰদৰ্শক 4 মোৰ নামত থকা ফটো পৰিচয় পত্ৰ issued by ইলেকশ্যন কমিশ্যন। প্ৰদৰ্শক 5 মোৰ দেউতাকে হামিদ আলীৰ নামে থকা 1966 চনৰ ভোটাৰ ৰাষ্ট্ৰীয় নাগৰিকপঞ্জীৰ কপি।
That's not a verification. Verification is down below.
Verification part is below. মই মোহাম্মদ রফিকুল ইসলাম পিতা মৃত আব্দুল হামিদ এই সত্য পাঠকাৰী ধৰ্মত প্ৰতিজ্ঞা কৰি কওঁ যে মোৰ এই শপতনামাৰ সকলো কথা মোৰ জ্ঞান বিশ্বাস অনুসন্ধান মতে সত্য জানি এই সত্য পাঠৰ তলত মোৰ স্বাক্ষৰ কৰি আজি ইংৰাজী 16/12/2013 তাৰিখে কলিয়াবৰ মহকুমা নটাৰী পাব্লিকৰ ওচৰত সম্পাদন কৰি
That means he's not deposing to the, he's not deposing by the record. He himself doesn't depose by the record. He is exhibiting a document, but says that it is true to his knowledge.
with knowledge. Yes, that should have been as per record, that should have been mentioned. But my lord, it is, lordship is very much well experienced that it is the mistake of the counsel. He should have clarified this. Because I don't know which is the matter of record, which is the personal knowledge and belief.
I don't know. Both have been trained. Once we say that the lawyer is a learned lawyer, many mistakes doesn't cross our eyes.
Learned will be reflected from the conduct. So here
I
he
don't
should
know.
have specified which a part of the.
It's a part of our training, Mr. Mahmood.
Well,
It's a part of our rigorous training. My sister has more experience in training than I. She's been a judicial officer all along.
yes.
A vast experience she has gathered. And we have been trained that once a lawyer is a learned lawyer, if we think anything else, there would be a wide protest from the lawyers' fraternity. And we are afraid of it.
I am not only for particular. Well, here actually lordship is well acquainted with
And
the
where is
fact.
this cross-examination? Do you have you annexed the order sheet?
Cross-examination, my lord,
Have you annexed the order sheet here? No.
order says I have not annexed. And here lordship would say cross part is there, page 60.
No, page 60 is DW2. I'm sorry.
DW2, yes, cross
Yes.
part. Here, this part I do not see any cross.
Yes.
So far this procedure is concerned. Then, my lord, the DW2 is Dhoni Ram.
DW2 is also an interesting witness. He does not take responsibility of any statement. He says that I know the name of father's name of his Abdul Hamid. Then he says there is a voter identity card in the name of Rafiqul Islam issued by so and so.
That is his responsibility. He is the third person.
He doesn't take
How to
responsibility
travel,
of
he
any
can
statement.
travel. He is a Gaura where the procedure resided for some time. Then, my lord, his certificate has been also exhibited. Kindly see the certificate which I have issued has been exhibited as Exhibit 3. Exhibit 3 is my signature, page 60.
But you see,
Page 60.
this evidence is on, this evidence was, cross-examination was recorded on 1/3/2021.
Yes.
In 1/3/2021, he says that his father came 22 years back.
Yes.
That makes him post 25/3/1971 person. How does it help you?
No. Yes, it will help me because this is the second resident. First resident is Kodamguri, and Kodamguri's Gabura has also issued a certificate that Lordship may kindly see. There are 3 Gaburas, my lord. Actually, my birthplace is my lord Moamari. Kodamguri. Now, Kodamguri's Gaburi.
Come to page 64.
I'm coming, my lord. Kodamguri's Gabura has issued the certificate.
I'm there. I'm faster than you. That's the difference. I'm at page 64. That is the Kadamguri's.
63 star.
I'm at 64. In
64,
64, come to line number 6 from above. 5 from above. About 20 years ago, he, for a better living, he stayed there.
Yes.
So 20 years. 20 years is 2022. He is less than 20. First Gambura says 22 years.
Yeah.
So this 2 years is washed away by the second Gambura who says that 20 years ago.
He is the first Gabura where he took birth.
We don't know. You see, I don't read by and make it by heart and come. First evidence is of first Gambura.
Yes.
Whoever he may be, he may be 1, 2, 3, 4, whatever. Second, this first Gambura says 20 to 22 years back he came. So this 21 and 22 years is washed away by the second Gambura at page 64. He says 20 years back. Then
20 years back, my lord,
we don't know.
this proceeding. But his father is, there is a linkage. There
We
is
don't know.
linkage. His father's name is Abdul Hamid, and his name has been recorded in the voter list of 1965. Kindly see page 18. Page 18.
Then please come to this.
Page 18, my lord. This is Kodamgiri village. Here my father is Abdul Hamid. His name is recorded.
You see, I don't remember the names. I only remember the sequence. Come to page 69. Now somebody comes and says, 22 years ago, he married so-and-so and came to livelihood at Bhamuni Patha.
Yes.
One witness says he came to Kadam Guri 20 years ago. Somebody says 20 to 22 years ago. Third witness comes and says 22 years ago, he shifted to Bhamuni Patha.
But every places Gauras have deposed. Maybe differences in years, in number of years. But here, my lord, apart from that, let me show the vital documents. 65 voter list is in the name of my father, page 18.
Now there is another brilliant man. Your best witness comes at DW5, page 72. Your best witness says the forefathers of the opposite party was a resident of Kadamguri.
Yes. That is on record.
Where is the storyline?
Lord?
Where is the storyline?
No, here from the very beginning, our state is clear that I took birth at village Kodamguri, where
There is
my
only one explanation, Mr. Mahmood, that they are all residents of independent India.
yes.
Everybody is independent. They don't have a storyline. A says something, B says something, D says something, E says something. Everybody has a different storyline.
There may be, my lord, every person do not think alike. Every person's statement may not be tally
Correct.
with others, but
Correct.
crucial thing is this 65 is there.
Correct. Last time I
66 is there.
went to a tailor. He took the measurement of my stomach. he said it was 42. By the time his cutter was cutting the trousers, he made it 50. Then I told him that 50 is not my waist length. Then the third man came, he made it 40. And then I can't wear that pant. Everybody has a different storyline. One says that why will this man have 42 as waistline? It should be 40.
Now,
I have a unique experience.
yes, well, those things are there, those are a matter of record. And here Lordship would kindly say, my name appears with my father. My name appears with my father.
Nobody has introduced your father.
Whether?
Nobody has introduced your father.
No, Gawara said he is the son of so-and-so, Abdul Hamid.
Well, Hamid, when did he come? Please show us the evidence. When did he come?
My,
We are asking for bail.
my lord, yes, I am for bail. My private
That's
visit
fine.
Lordship will be satisfied that my father's name is recorded in the voter list of 65. My grandfather's name is also recorded in the voter list of 1966. My name is recorded in the voter list of 2005 along with my father. Gawura have deposed that I am the son of late Abdul Hamid. And there are some shifting of residences. Those are clarified in my evidence. So, my lord, I hope and believe that your lordship may kindly grant me
No,
bail.
we'll ask Mr.
And
Verma.
after receipt of
Mr.
LCR,
Verma, can you expedite the beginning of the LCR?
Yes, Lordship.
The past two orders, the LCR has not come.
so
Lordship may,
First order was passed on 20th March.
in receipt of LCR, some protection was.
No,
We are-
we are not satisfied.
No, your lordship should
Lordship
say this.
can,
We'll give you a direction.
direction
How
and
much
the
time?
last orders, reflection on it, Lordship, that's.
What you call 10 days from today would be enough
10 days, yes, Lordship.
from today. Please suggest a date.
Lordship, today is 22nd.
1st of May.
First is a holiday, Lordship. Lordship can fix it for the 5th of May. Second is Friday and third is Saturday, so.
Make it second because Mr. Mahmood is insisting on bail.
Lordship, we'll have to satisfy this court, Lordship.
That's okay. See,
5th, Lordship.
huh?
5th
Fifth,
of May. 5th is a Monday.
Monday.
We can get it by first, Lordship, but first it would be a holiday, so.
I understand.
Lordship can fix it, then second is Friday. That is why I was insisting on Monday, Lordship.
Monday की तारीख में,
Past तारीख.
first तारीख.
Mr. M.U. Mahmood, learned counsel for the petitioner, prays for bail to the petitioner. Next one. A guideline that CGC appears for the Union of India. Mr. Ms. A. Verma done it. Standing counsel for the FT matters. Mr. I just forgot the name. I am Islam, done it counsel, case on behalf of Mr. A.I. Ali, standing counsel for ECI. Mr. P. Sharma, done it senior government advocate for the state. Present, next parade. We observe that by order dated 20 March 2025, the records of the records of FT within bracket K, bracket post case number 789 of 2015 was called for from the office of the learned member, foreigners tribunal within bracket 8th or now bound. However, as per office note dated 11/4/2025, the LCR is not received. Next per accordingly, we request the learned standing counsel for the FT matters to take the assistance of the home political and political within bracket B, political and home within bracket B department to obtain the records, said records to produce before the court. Next paragraph. Learned standing counsel for the FT matters shall send a downloaded copy of this order to the concerned authorities so as to enable them to obtain the records. Next paragraph. List on 5/5/2025. Next paragraph. The learned counsel for the petitioner has granted liberty to renew the prayer for bail on that day.
My lord, one small sentence, my lord. On that day, bail may be considered.
We have already said that. We have already said that.
Hello.
Last line is that only.
Item 3 for motion.
You got instructions, Mr. Verma?
Lordship, I have come after a long time. If the instructions are there, it will be with
Okay,
Mr. Turner.
just look at this order.
After some time, Lordship, he. will be
Just look at
coming.
the order.
I have a copy.
Just look at the order.
Paragraph 6.
You take it up at 2 o'clock. At 2 o'clock.
Yes, Lordship. I don't say date for order. 23, 12, 23, no? Because I was going to-
Item 5.
Deep.
Mr. Verma, here also record has not come. We direct the learned member Foreigners Tribunal, 3rd Nagaon to send the records. Otherwise, we call for the personal appearance of the superintendent. That will expedite.
Yes, Lordship.
Okay. There's no representation from the
Lordship is
petitioner.
directing me to get the
No, no.
records. No.
We direct the tribunal to send it. Otherwise, we'll call for the personal appearance of the superintendent.
Yes.
Uh, there's no representation from the petitioner. It is seen that pursuant to order dated 19/3/2025, the registry has sent a requisition on 21/3/2025 for the records of FT case number 83 of 2021, decided on 18/12/2024 from the office of the learned member, Foreigners Tribunal within bracket 3rd, bracket close Nagaon. So however, as per office note dated 11/4/2025, the records have not been received. Next paragraph. Accordingly, the registry shall send a press requisition, reminder to the learned member, Foreigners Tribunal, 3rd Nagaon, at the following email address of the said learned tribunal to send the records referred above. Next paragraph. The learned tribunal is also put to notice that in the event the records are not received, appropriate orders may be passed on the next date to call for the personal appearance of the superintendent of the said learned tribunal. This address, take it from address with the email address. Next list from 2/5/2025.
Item 6.
Yeah, please, your Lordship, this is a
The
contested case,
records
Your
are not
Lordship.
received. We'll have to wait for some of the records.
This is also no-go, Lordship. And looks
Same
like the
tribunal. This is same tribunal.
same tribunal, Lordship. Even the first one where Lordship has asked me to obtain the records is also the same one.
I think that was 8th.
8. I didn't hear.
That was perhaps 8th.
Lordship, my apology, Your Lordship. My item number is 5. I was mistakenly thought that my item number is 6, Your Lordship.
Okay, you were there for 5.
Your Lordship, I'm there for 5, Your
Oh, okay.
Lordship.
Miss
Jibora, Lordship.
G. Bora
Lordship.
in the earlier item. The record of cases. We have called for the records
Lordship.
on 2nd of May.
2nd or 5th, Lordship. I heard
No, this yours was different.
5th and this is
This we are
2nd
sending by through the registry.
through the reminder, Lordship.
A reminder.
But I was not in interim, Your Lordship.
Huh?
Interim order, Lordship.
Interim order will have to wait because this is
Lordship.
4 years back.
Lordship.
Just wait for some time.
Lordship has fixed the date as 2nd of May.
2nd of
Item 5, 2nd of May.
item 6 also, same order. Miss SS Zia, learned counsel for the petitioner. The respondents are there. Here, the order pursuant to order dated 19/3/2025, requisition was issued on 21/3/2025 for the records of FT case number NFT within bracket number 3, bracket close within bracket D, bracket close 3/8 of 2015 from the Office of the Learned Member from Foreigners Tribunal, 3rd, Nagaon, Assam. Same order. 2nd,
Public.
Item 7 for admission.
Your Lordships. My lord, in this matter, the learned advocate general, my lord, could not complete on the previous occasion. And I have to give a brief reply to that.
I.
That is regarding, my
Advocate
lord,
General's argument was not concluded.
my lord, the last order reflects, my lord, his argument was not.
Lord,
concluded.
may I please your lordship? Lordship, matter may be possible for timing, lordship, after some time.
Just tell the senior counsel, Mr. Chaudhary, when, because he will come by then. He may not spend his time here.
Lordship.
Just consult your Advocate General and tell him the time. He'll come by then.
Yes, lordship.
Just tell the time to Mr. Chaudhary so that he can come on
Give
the
me the
time.
Don't more time.
After 1 or
Half an hour, half an hour. After half an hour, he said.
okay, sir. Obliged, lord.
Item 8 for admission.
Any progress after that?
The person to Lordship's last order, the department has already taken the steps for release of the interim compensation. Malab. The concerned secretary of the district legal service authority have been communicated. But what has happened from the district legal services authority, I have to get that instruction.
So far as not in this particular case,
My lord.
but we had a general uh, discussion on this compensation matters. And I don't know whether it is true or false, but every district legal services authority have shortage of funds.
Lordship.
So unless this is a earmarked money to be transferred, I'm not very sure of this particular case. But
Well,
by and large, we have been told that there was some shortage of funds.
True. My lord, because in fact, my lord, another PIL is going on as regard the fund requirement of the for the compensation amount. There, my lord, I got the information that fund requirement is about
Because last time I expressed when I was when I had taken up the matter last in that PIL, then I distinctly remember saying that the authorities in making a budget is doing a wrong way of creating a budget. Because this is something which is unforeseen. And I made some comments. But otherwise also in the administrative side, when we have the discussion on this,
well, in fact, my lord, I have to get the clear information in that regard also, because that was the position in the last budget. In the last budget, my lord, when it was there,
since
now-
then there's
now-
no change.
because 9 crore was an earmark and the
I
requirement was.
understand, but we, so far as I vaguely remember, because you see this vacation and I was out in a different bench. I've forgotten many things, but insofar as the budget scenario is concerned, I don't think any substantial budget has been given to the District Legal Services Authority in the last budget presented in February, March.
That position, my lord, the detailed position I can take.
Just a
I
moment.
can take. Subject 45 crore, which is like 110 crore. 45 lakh.
Mr. Nath, subject to what Mr. Saikia says, we have not heard him. On your prayer, we give you time till Friday to get instructions. Because specific instruction, if you hand over this 2 lakh rupees to the District Legal Services Authority without earmarking that for this purpose, then there is every likelihood that the last pending, the earliest pending matters would be paid off. So when you take instructions,
Follow.
please pass on that instruction that this could be earmarked funds under the facts and circumstances of this case, so that the authorities as well as the DLSA, they know that what money they are handling for this purpose. In this case, that is this WPC 8771.
Mother.
Mr. Saikia, we give them some time, because if money is coming, we don't want our orders to create a bottleneck so that you don't get the payment. Please, okay.
No, as it seems from their communication, they have taken up the matter with the DLSA. From the DLSA's fund, they are.
No, we don't know. Taking up of the matter and placement of funds and then taking up the matter, there's quite a lot of difference so far as our limited understanding is concerned.
But I'll get the instruction whether specifically they have also given the amount or not.
Yes.
Logic.
Okay.
For
Because these funds can.
apart from the
There
normal.
are two ways of looking into it. Number
No.
one,
Logic.
you send it to the DLSA and release it. Otherwise, in this, under the administrative side, you under that circular of the government of 2015, you also have funds in the disposal of the district magistrate. Even if the deputy commissioner releases that, we have no problem with that. it's not necessary that you route the money only through the DLSA. If the district administration can otherwise hand it over, then also it's quite permissible.
I'll take the instruction by in what manner they want to.
And we give in the order, we give both the options open. So that the authorities will take a call and by Friday, then be able to tell you.
Lordship.
You will get it by Friday?
Lordship. If not inconvenient, let it be on Monday. I'll because
Monday.
yesterday was a holiday.
Okay. Mr. Saikia?
Well,
Saturday to plus one month.
And Mr. I. Saikia, and counsel for the petitioner, as well as Mr. D. Nath, and the senior government advocate. For the health, who's appearing? Mrs. Sharma was there. Mrs. Ash Sharma, Learned standing counsel for the health department, representing respondent number 8, and Mr. P. Rahman, and counsel for respondent number 7. Next para. Pursuant to order dated 27/3/2025, the learned senior government advocate has produced a copy of letter dated 12/4/2025, issued by the Undersecretary to the Government of Assam, Women and Child Development Department, addressed to the Secretary, District Legal Services Authority, Bangaigaon, to take appropriate necessary action in terms of the said order dated 27/3/2025 in regard to the interim compensation and apprise the status of the same to the learned senior government advocate on or before 21/4/2025. Next para. Accordingly, the learned senior government advocates prays for some time to obtain instructions and inform the court as to the status of interim compensation, referred to in the order dated 27/3/2025. Next para. As the hearing before referred, letter dated 12/4/2025, issued by the Undersecretary to the Government of Assam, Women and Child Development Department, does not specifically mention as to whether earmarked funds have been provided to the DLSA, Bangaigaon, for payment to the victim. In whose in respect of whom the present writ petition has been filed, the Undersecretary to the Government of Assam, Women and Child Development Department, is directed to provide specific instructions to the learned senior government advocate as to whether earmarked funds for this case has been provided to the Member Secretary, DLSA, Bangaigaon. Next para. In order to ensure that the interim compensation is received by the petitioner and for the benefit of her son, who is the victim in this case, we keep it open for the state to take an appropriate call as to whether the interim compensation can be paid by the Deputy Commissioner from Bangaigaon out of the funds earmarked under the victim compensation. No, not what is that called? That 2015 OM for accident victims and extremist violence and those. What is that?
I'll furnish the
Ah.
from the revenue department.
Of the revenue department.
Revenue Department.
Okay.
That was from the Revenue
Oh,
Department.
okay, in light of the circular issued by the revenue department, dated so that you will get after some time. Huh?
Assam Victim Compensation Scheme
Uh,
2012, my lord.
Huh?
Assam Victim Compensation.
Assam
Scheme-
Victim Compensation
Scheme
Scheme.
2012,
2012, issued by
issued by the
down below the signature will be there.
Principal Secretary to the Government of Assam, Home and Political Department.
Principal Secretary to the Government of Assam,
Home and Political
Home and
Department.
Political Department. So this suggestion is only an alternative suggestion. Which can be explored in the event earmark funds has not been provided to the District Legal Services Authority, Bangaigaon. Next para, the learned senior government advocate shall transmit a downloaded copy of this order to the competent authorities to enable him to obtain instructions as regard the status of payment of interim compensation to the victim. Okay, and insofar this is one part,
That-
and the other is to hear the matter on merit.
My lord.
We fix a date for hearing also then,
Yes, sir.
irrespective of this independent
The payment.
payment.
My lord. Lordship has indicated my lord has indicated the OM of the home. The Revenue Department OM is my lord 15/11/2014. There is another for the Revenue Department.
The second, one is Revenue Department,
Uh,
OM
of-
dated
15/11/2014.
2014, issued by the Revenue Department. Government of Assam. These two are alternatives. Number one, number two, alternative. Next para. Independent of the issue regarding payment of interim compensation, as the case is ready as regards service and affidavits have been exchanged, this is the matter for hearing on 22/5/2025.
Well,
Gustav,
That can be fixed
next
on the
para,
next
however,
Monday.
next para. Nonetheless, let the matter be listed on 5/5/2025. To enable the learned senior government advocate to inform the court about the status of payment of interim compensation to the victim.
well,
And in the first line, you say, we propose to hear it. For which appropriate orders will be passed on the next date of this day. And then say, list on 5th.
my lord.
Let's-
Okay.
Item 9 for admission.
Gravely lordship.
Yes.
Lordship, this is an ex parte order, lordship. My order is as page 61, lordship. Lordship, what happens? in this-
Just a moment. Which page is the opinion?
Page 61, lordship. There are 9 petitions. There are
Petitioner.
So have you made Farooq Khan a party?
521.
This guy, Farooq
who
Khan,
put
a party
this?
बनाया ना?
How do you put this?
If I put it.
No.
Funny story. Mine for her.
In fact, we think that the petitioner has called for the second record to show that he's somehow related. And in this 880, sorry, in this 79 of 2010, the procedure was declared to be an Indian. Let's check up. We'll take it up after some time. We'll take it up at 2 o'clock. Let her go through the records. We'll take some time to see the records.
obvious.
Item 10 for admission.
I think the reminder has to go for the LCR lordship.
LCR has not been yet received. And on last date on 7/4/2000.
Hey, your name
Lordship A Kashyap on behalf of
And-
Sidas.
and Kashyap.
A Kashyap.
A Kashyap.
This is all
A Kashyap, London Council.
FT3
Same.
Nagar, same lordship.
A Kashyap, London Council enters, appears on behalf of the London Council for the petitioner on record. All the respondents are represented. It is seen that pursuant to order dated 24/2/2025, 26/3/2025, and 7/4/2025, this court had the registry has issued requisition and reminders to the member, foreigners tribunal number 3rd, Nagaon, on 27/2/2025 and 11/4/2025. Till date, the records of FT case number 284 of 2016 corresponding to FT case number 94/12, decided by opinion dated 5/4/2023, has not been received from the learned member, foreigners tribunal within bracket 3rd, bracket close, Nagaon, Assam. Next para. The registry shall send a requisition to the said learned tribunal through its following email address. Just to address full stop. Next para. The learned tribunal shall ensure that the records are received by 2/5/2025, failing which appropriate orders will be passed for personal appearance of the they are called Shristadar or they are called UDA.
Basically, it's a UDA lordship.
UDA. UDA oblique Shristadar of the said tribunal. Next para, list on 2/5/2025.
Item 9.
Item 11 for admission.
Item 11. Lordship, LCR has not been received here also. No, LCR, I'm like.
Kindly please Lordship, order dated 3/3/2025 Lordship.
LCR is there.
The lordship. They look, the pension recipe will not have.
Please, Verma, just go through it because he was already, the petitioner is arrested.
3 months now, Lord.
Yes,
December he was.
2012, 2024.
This is the
Just go
lordship,
through it and
second
then.
time litigation lordship. Earlier was declared foreigner. He is approached honorable court.
No, that's
This
okay.
is
Let us go through the records. Just go through it. We'll take it up at 2 o'clock. At 2 o'clock, we'll take it up. Let's go through the records.
Papa Manuel Buta also. Every item 11.
Item 12 for hearing.
I have filed an additional affidavit, my lord, on 27/1/2025. In pursuance of order of your lordship.
Lordship, item 12, the LCR and the file is with us. So Lordship may fix it up day after tomorrow, Lordship.
Item 12.
Yes, Lordship. It
Okay,
was.
let us see. Mr. Sheikh is referring to an affidavit filed, whether it is there or not.
Now, my friend has just told me to pass it. Which has
27/1/2025. Additional affidavit. Possibly it is tagged to get record.
It's there, it's available.
Yes, madam. All right, madam.
Okay, day after tomorrow then.
Yes, madam.
Okay.
No, not.
Mr. M. A. Sheikh, learned counsel for the petitioner is present. All the respondents are represented. Next, on the prayer made by Ms. A. Verma and standing counsel for the FT matters. List on day after tomorrow, 24. So as to enable her to go through the records and address the court. List on so and so. Okay.
Congratulations.
Item 13 for hearing.
General decency.
Yes, my lord. I have
Just.
mentioned.
His days available.
Lordship,
Just.
Mr. Deepankar is appearing, Lordship.
So just.
He's in next.
Okay. Is the postmortem report available in the
Yes.
writ petition?
There, it is there, Baba. It is flag, Baba. It kindly. There are two postmortem report, Baba. One is carbon copy, one is original. It is flag mark, Baba, if kindly we can indicate.
There should be two postmortem reports.
Yes, my lord, there are two. But, kindly, can I indicate, my lord?
This carbon copy one.
One is carbon copy, one is original.
Then perhaps the state has many things to say. Unless you have a good explanation, is and the entire bundle carries no weight for us. I'll show you why. See the flag in the first file. Green flag, I have right side, yes. Read that document.
It's this one.
And the previous pages indicate that the office of the DGP issued what you call a crash message to the IO to submit a FF. After that, this has come. Correct. Now, as per the case diary, postmortem was done at GNRC.
But this copy has come from GLC, it's not.
That is in the first part.
Lordship.
The carbon copy is from GMC, so it's a manufactured report. Unless you satisfy, you have a good explanation. We don't have to read any other document.
That I'll see, my lord, but it is sealed and signed by the authority, proper authority, my lord. Under what that I have to explain under what circumstances or they have to that I have to. One,
And there's a document here, which is the inquest report. Inquest report doesn't show two wounds. One entry and one exit wound. On the head, it's not there. And there's another medical document which says entry oblique exit. That means at the stage when inquest was done, the person doing inquest had no idea what he was looking at, he or she was looking at. Because the entry oblique exit, that's how it is written.
but
And whether this GNRC would have a forensic department, we don't know.
this report is monetary GMCH.
But then the IO says, as per the case diary, postmortem was was done at GNRC, and he wanted some time to get the postmortem report and close the matter.
See, Malad, why they have said GNRC, Malad, I'll see, Malad.
That is one part. The second part will.
I don't know Malad, whether he was admitted at GNRC first, then he will take.
No, he was taken to GNRC. That is there.
Gotcha.
One of the in the opening part of the case diary, it is there that
2%.
he has been sent to GNRC,
GNRC.
where he died.
Yes, Malad.
So
Then
place of death, as per the inquest, also is GNRC.
GNRC.
That's one part. There's second part, which is more interesting. We have not been able to deliberate at the bench. We have not been able to deliberate on that. But the case diary is again unnumbered, even though it's this is a case diary of a serious nature where two people are alleged to be shot dead by the police, and the case diary is not properly maintained.
But in fact, the additional SP Nogao, he is inquiring into the matter, Malad.
No, we don't know.
From-
At one stage, after quite some time of investigation, the IO was changed. But the final report is given by whom we don't know. It may not be the same IO who was entrusted. There's a order to entrust somebody as IO.
Yes.
After that was given the final report, we don't know. We could not check the.
The last page is Malad, the additional SP crime Nogao. He has
Name.
He's Joyanta Borua.
That means there will be a third IO.
Logic.
There's no continuity with that
Logic.
investigation. And then comes the problem of a unnumbered case diary. In between documents are not numbered. So which document is getting included in the case diary, we don't know.
Some are numbered, but the order sheets, these are the last order sheets are not numbered. But the
No, in between documents, with those documents which are referred to, they are not numbered. And there's no in the initial brief, we don't even know the entries, how they are, on what basis these documents are coming in. That is in the last file. That is the entries in the case diary, but.
So this indicates part A, part B like that. Well, some are numbered, but few pages are there without number.
So you see, we are just, you have seen, we have just spent only 2 minutes to look at the documents.
Logic.
We just did a sample test to have a document seen in the case diary, the entries in the case diary, and to find it from the first file. And then there comes a mismatch. And therefore our eyes went to this document. Because if these are maintained in serial order, we would have understood. But in the short reading of the document, we can't say whether it's placed in seriatim, because the postmortem report comes in the first. So the order of maintenance we don't know right now. And that is why we are jumping into a conclusion that perhaps with that entry of the police in the case diary, we really don't have to spend any time on this case diary. And the follow-up would be investigation by an appropriate authority. If we don't have confidence in the maintenance of case diary.
As regard the maintenance of case diary, whatever is there,
No,
I can't go.
you see, so far as the bench is concerned, we have anxiously thought, and though we have not deliberated on that much, but this is the prima facie finding which we are arrived at. And unless you have a good explanation, you have nothing in the case diary, in fact.
As regard the postmortem report, the details are mentioned in the case diary. I'll submit
So
that.
you'll not be able to go unless you see in the order of maintenance. Unless you have the IO with you, you will not be able to go through the case diary in this case diary. I don't think so. Please take assistance, otherwise you will not be able to respond to the court query. You'll have to get him in your office and then take
Yes, sir.
instructions.
I'll call the IO.
Yes. Because there are the two sequences. I'll just deliberate with my sister and then tell you.
Madam. ये दिशा में
Yes, my esteemed sister has correctly said. You see, so far as we understand, in just an overview of what we are trying to find out. Number one, the nature of injuries to person's hand. Number second is a corollary to the first, which is the entry wound, what is the exit wound? What is the finding on the with regard to the entry wound?
in the PM report.
In the not even the premier, you see the what you call you. Please go through the inquest first. You have done a inquest through an untrained officer. He or she has not been able to identify the nature of injuries which were sustained by the dead body. This is in respect of one of the deceased. He or she says, the person doing the inquest, he said that bullet injury in the head. But then if there's a bullet injury, my sister has correctly said that, you see, what happened to the bullet? If there's only in the inquest, there is only entry oblique exit. That means there's one entry, and the that surprises us because if there's only one wound, it can't be an exit wound. So therefore, the approach of the magistrate doing the inquest doesn't appear to be correct. And then what happened to the ballistic report or the armory report? Which of the arms were in fact sent? Because you will have a policeman on duty. You have a particular gun from which shots were fired. In the FIR, it says it was indiscriminate firing. So indiscriminate firing in the when we see that case diary, we don't find that ballistic report or armor report is there. This privacy we are saying we just flipped the documents for 2 minutes. We don't know we have done a
Lordship.
good job or not.
Lordship, lordship.
We may be erroneous in our appreciation of the documents.
No,
But,
see.
But
I'll
when the
just take up.
when the matters are sent for postmortem, the second is that to make an inquiry with regard to the bullet of the armory which were used. The initial entries in the case diary doesn't reflect that. That effort was done to correct the number of bullets which was spent in the police firing. Then what happened to the armory report with regard to the bullet which was actually caused death of these two persons? This is the second thought. So all these are we have to be satisfied privacy that the investigation by the state police is done correctly. And the third part we have already said, an inquiry is going on. Request from the DGP for expediting inquiry appears to be okay. But in that note, it says that please give an FF,
Final form.
final form. Final form again has both meaning included. It's a case of what do you call finding against the accused person, or it says that closure report. It can mean both.
Normally in.
And near to those documents, we don't have a circle inspector's report. So why would a DGP look into case diary? Circle inspector's report.
Well, here, my lord, investigation has been conducted by done by the IO, who is additional SP, my lord, additional SP crime, and the range DIG, he is, my lord, he has appointed him. That is,
Who will be the circle inspector in this case? Who will make the first supervisory note?
my
Who
lord,
will be the police officer who will do the first supervisory note in the case diary?
my lord, the additional SP, he is doing, I'll see. Because the incident took place at Karbianglaw.
Yes.
And the officer at Nogao, he's doing the investigation. So they possibly the range DIG, he is doing that. I'll check up. I'll talk to the IO.
Please have the IO with you,
Yeah.
then only you will be able to
Yes, my lord. All
tell
this-
us.
All these details, my lord, I'll take for.
Yeah.
I'll take.
Because this is only a few questions we have now with limited reading of the case diary.
My lord.
Next scrutiny, my esteemed sister will be doing it instead of me and when
Well, I'll call him in this week only, my lord. Oh. But can I pray for a date after 7th, my lord? Because of Panchayat election, my lord, police officers are very busy, my lord.
after 7th
After 7th,
of May.
May, my lord.
Okay, then we're fixing it on 13th May.
Lodge.
Uh, See, both sides are represented. Next panel. Mr. D. Goel and counsel for the petitioner, as well as Mr. D. Nath Lanet, senior committee advocate. Both pray for adjournment. Next panel. List on 13/5/2025. You see there's another problem which you'll face. In this that referred letter, which was flagged, in that letter, it said that as per the case diary, postmortem was conducted in GNRC. Correct. GNRC, and thereafter how this went to the GMC, we don't know. The issue which will trouble you is that there cannot be two postmortem.
Correct.
So once an IO says that a postmortem was conducted, is a positive sentence. Therefore, it is the postmortem by the GMC would be an inconsistent document, and it erodes the credibility of the investigation. And then there are three IOs, you said.
Three.
Please take a call, thoughtful call as to from whom you will take the instructions.
The last IO I have to,
We don't know. We are not saying anything.
I have to,
We are not saying anything. We are just posing a query and leaving it there.
in fact, just I'm for a moment indicating. The case was previously investigated by the following IOs. Inspector Kohesar Bora, he was OC Haplong. Then Gaurav Agarwal, APS SDPO Lokhipur. Then Anurag Sharma, APS SDPO Lokhipur, because change of officers possibly. Then Malot Kolepradip Bhattacharya, APS SDPO Lokhipur. Then Dinesh Kumar, SDPO Lokhipur. Then Malot Noyanmoni Bormon, APS Additional SP Crime Karbi Anglong. Thereafter, this IO.
So 8.
7.
Now that's why we said we are not saying anything, but you'll be required to take a call from an appropriate officer who's made those entries.
Got it.
Otherwise, if there's no continuity, because you see, that's why we are questioning the when the case diaries are not numbered, then how the documents are coming into the case diary, we don't know. So you'll have to address on the sanctity of the case diaries and entry made therein, documents which is coming in, and therefore who will be the appropriate person to give you specific instruction on that will be your call. We are not saying anything.
I'll start with the present IO, then I'll go to the others. That will be my
Whatever way.
I'll try my best.
You are the master with the file.
I'll do one.
Take an appropriate call. We are only secondary visitors to that.
Lordship has indicated so many things, but I'll just.
No, we have said many things, but I have strange ideas. It may not be palatable to you. We have in various programs when you meet the officers and the Home Department, we have also told them a story about maintenance of a pocket diary for each IO in each case. perhaps not materialized. I I give you an example also, not you, maybe somebody who was handling the matter. We were taking up a criminal appeal. And when in the bench, when I saw that record, I could verbatim express what was the manner in which the court proceeded in the trial court. Those were my formative years in the practice. When we had no work, we were sitting in court observing the proceedings. And then in that proceeding, I remember it so well. Even after 20 years, I was able to recollect what was there in the record, in the division which you are taking up the matter. But the officers, they don't. The problem is that if the IOs do not have a continuity, they'll have to refresh their memory from the case diary. And how many people will have the energy to look into the case diary of 100, 200 pages and then refresh memory and then address the court? They'll not be able to do it. So unless the state government takes a proactive call for a particular claim, the IO will have to have a pocket diary, just like the Lat Mandals have. They prepare everything in chitta and pencil. That helps them to make final entry in the Jamabandi, which is the record of right. They may make mistakes in the calculations. Those are by pencil, and therefore it can be appropriately corrected and then entered here. So to write a case diary, unless you have a preliminary notes with a pencil, not be able to write a case diary. Okay, resume after 5 minutes.
They given their consent on the chitta.
So who is the beneficiary? Is it the appellant or is the private respondent?
Private respondent. What happened? The private respondent number 3. She is one of the legal heirs of the original owner. She came before the revenue appeal, and is culminating to this the intercourt appeal. The land was mutated in the name of her husband. That's one number 3. And he had executed 2 sale deeds in favor of us in 2003.
Where is the Jamabandi?
Jamabandi, my lord.
Jamabandi or copy of
Yes, yes. Yes, 69, my lord. Serial number 6, there is an order.
6 and 9, my lord.
In this page 69, who are the parties before us? Who is the appellant?
I am Safika Hussain Ara Begum. She is in serial number
9, sir.
9. 9. No.
No. First is entry, column number 3. Where is the name? Where is the name of
My lord, at
So-
page serial number 30, my lord.
30?
30. At page 71, my lord.
Safika Hussain. Because Safika Hussain. Yes, Sophia Hussain. 27 and 30 minutes.
This is appellant number 1.
Yes. Appellant number is Safika. 30 minutes.
30. Who is the
30.
appellant number 2?
Sophia Hussain Ara Begum. She is serial number 27.
27.
My lord.
But then 26 also is same name, Sofika Hussain
Yes, these are all
Ara Begum.
Double entry.
double entry.
26.
So there can't be a double entry.
20.
Yeah, actually, what happened, my lord, Lordship, we have seen numbers of
when it's computerized, then this double entry has
No, my
earlier
lord,
manual.
my lord, there are two ducks maybe, my lord, 146 and 149, so might be, my lord.
Which are the entries?
Entry is six and nine.
9,
6 and 9.
my lord.
6 is
Then
my vendor and
if-
9 is.
if 6 and 9 are the relevant entries, then Ms. Barwa appears to be correct because there is serial number 13.
Serial number 6 is my vendor's entry, my lord. Manohar Ali.
No, because we are, that's why before you begin, we wanted to understand the land position.
No.
13 is also Sofika, correct?
13.
If you come to
my
serial
lord.
16 of the remarks, here also you will find the name of Sofika Hussain Ara Begum.
They sold.
They
15, 15 also it is there. So we want to identify the land first.
after the purchase, my lord, some lands we are also sold to the other persons.
This was subsequent.
Subsequent.
My lord, during the pendency of the matters, my lord, they have sold the land, so this is latest Zamabandi, my lord.
Not-
That is why,
Privacy cannot be.
it's-
Because you are showing that this is an entry of at column 3, item serial number 26, 27, and 30. 26, 27, and 30 cannot be by way of an entry number 6 in the remark column. There's something wrong. Once we can't identify the land,
There are two mutation. One is 1913/8/2000.
Mr. Gupta, you please try to understand. I'm just trying to find out with these entries, what is the description of the Suk land? And can it be found out from the Jamabandi?
Right.
Yes.
Correct.
That's the first
Right.
attempt. And
Right.
then we'll go to the facts. We have
Yes,
not
yes.
even heard you on facts.
Yes.
We just want to know the land first.
Yes.
Then we'll go for hearing.
Yes. As per orders, it is.
Then my lord first come to serial number 6, wherein this 2 bigger, 2 cutter, 12 lucha, or 2 dark numbers, 146 and 149. That was mutated in the name of my vendor, our vendor. Then by a common order, this is 9 on 19/3/2004, this 2 bigger, 2 cutter, 12 lucha, mutated in the name of appellants. And this is the.
Mr. Datta and Ms. Barwa, you have started asking this question, why? We'll tell you. Please come to page 69. You are already there. 69. Dark number 146 is 2 bigha, 2 katha, 19 lacha. 149 has 2 bigha, 3 katha, 9 lacha.
Correct.
That means it will be 5 bigha, 1 katha, 8 lacha.
Yes,
Total land.
total land.
You
5
were
bigger, 1 cutter, 8 ocha.
you were showing us the first entry number 6. Entry number 6 is 2 bigha, 2 katha, 12 lacha.
Right.
12 lachas, correct?
Right.
Second is you are showing us serial number 9.
Hmm.
Serial number 9 is 2 bigger 2 kata 12 HRs. Out of total land, we have 5 bigger 1 kata 8
Eight
HRs. So perhaps it's not adding up.
In the both the ducts, 146 and 149.
So what is the land actually which is being mutated in this two? It's not very sure.
2 bigger, 2 kata, 2 luchas. 12 luchas.
Of two dag.
Of 2 dag, madam.
So what is the actual area in one dag? We'll have to find out that we're
That-
not being able to find out.
Cell it is there.
And that's
Send
a
it, send it.
and that's a pure question of pure question which has to be decided in a civil suit.
My lord.
You've not been able to.
No, that's absolutely correct. One legal question, if we say subject to the approval of this honorable court, the entire matter.
No, you can make your submission without approval of the court because what we'll approve, we don't know.
Why we always said a lot, because our all submission is subject to approval of this honorable court. We are all expected that my submission would be approved. That might not can be appreciated. Now, only one legal issues, my lord. Yeah. They have challenged, they disputed my title, our title, my lord. They said that Manohar has no right to convey the land. And that is their contention in the revenue appeal first. So therefore, once there is a
Who is
dispute,
what is and who is the what is it? Which is the entry of the what do you call private respondent? What is your name?
no, its her name was not mutated.
His name is not there. Okay.
Her name was not mutated.
Okay.
She is admittedly one of the legal heirs of Abdul Ghani.
Abdul Ghani.
Abdul Ghani was the original owner.
My lord, if
He
the-
has two sons, Inamul Hussain and Yajan Hussain. Now, she is the daughter of the first son, Inamul Hussain.
Just a moment. Come to page 72.
Page number 72.
72. So what is this Abdul Ghani here? Is the Jamabandi in Assamese?
Yes.
I find it more convenient. Where is the name of Abdul Ghani here?
My lord, they were both, Abdul Ghani was the father of Inamul Hussain Hazarika and Hirazan Hussain Hazarika. Abdul Ghani, he was the, my lord, original potader of the land, my lord.
Where is his name? His name is not there in page
Yes, my lord.
72.
He are not there. My lord may appreciate in this is the original Chitha. Then after the settlement, then the new names came here. You see,
Where is the
these all
Chitha?
probabilities.
Where is the Chitha?
The Chitha is not here.
Then
But this is not a dispute between the parties, my lord.
no,
That-
My lord.
whether you are in dispute or not is not the
Yes,
main issue. Whether we have been able to understand what, the genesis of the land, that is the
Yes.
issue.
This was the, my lord, with due respect, this was the question. My lord may be pleased to peruse page 94 for a second. When the matter came up at the initial before the Honorable Board of Revenue, the same questions were put up and they have even observed that part also. See, page 94, my lord.
No,
would be
we'll
pleased
come to
ex-
you later on because Mr. Datta, we have not even heard him. So on merit, we will not hear you. We're just trying to understand the
Yes.
description of suit land.
my
Now,
lord,
Abdul Ghani's land, so far this record is concerned, my lord, we could not find out.
It's not there.
No, no.
Can we look at your sale deed? Where is that?
Yes. Page 51. Two sale deeds are there. One is at page 51. 51 is a translated copy. Oh, it's not particular. Mati Bikri Dolil, as page 53. Sofika Hussain. Appellant number 1.
Mr. Datta,
My lord.
we'll look into this on a different angle. Some orders of mutation were passed.
Correct.
Agreed by that, she came to Board of Revenue
No.
in appeal. No, she's the appellant.
She is the appellant before the board of ADC.
Board, ADC, no, Board of Revenue.
The board of revenue, we went. my lord.
No, can't be. Can't be.
ADC?
She filed a.
Yes, that is page 93. We have seen that.
Yes.
Correct.
Sorry. my lord.
She's the appellant before the Board of Revenue. Board of Revenue dismisses it. She files a writ petition.
No, we filed.
No,
When 84, my lord, kindly pass.
page 148, this writ petition is filed by her. Sofika Hussain Ara Begum.
That is we.
You are Sofika.
Yes.
Okay.
What happened, my lord? Before ADC, they are challenging the order of circle officer. The ADC has allowed their appeal.
Oh, I was wrong. I was thinking that you are Sofika. No. Then I'm wrong.
No, my
It
lord,
is very confusing.
my lord,
Yes. This Sofika was the appellant in the Board of Revenue. You
Yes.
were the appellant.
In the ADC, before the.
Before the ADC, my lord, before the ADC, they went to appeal against the order of the circle officer.
Correct.
yes.
Then that appeal was allowed.
Okay.
Being agreed, we went to the board of revenue. It's Sofika.
That was dismissed. You came
Then
in High
again
Court.
came before the learned single judge.
Now that was dismissed. You are in appeal.
Correct.
This Board of Revenue order
My lord.
is come to page 101.
Yes.
This is a finding of fact. At page 101, para 10.
Yes. Para 10, my lord. Para and 10 and 11. That is,
So para 10 first will come to 11 thereafter.
yes. Before this code, it is not clear by documentary proof how late Manohar Ali become owner of total land 2 biga 2 kata 212 acres of land under patta number such and such, and his name was mutated in place of pattadar number such and such. When mutation of the name of Manohar Ali not supported by the contention and claimed of present appellant, it is legally not sustainable in the eye of law.
Since ownership and mutation
Yes.
of the vendor of the appellant are found not
So the,
as not correct one. So appellant cannot claim mutation on a basis of on a wrong basis, and revenue law cannot allow mutation on the basis of wrong entry made in the revenue record.
correct.
And so there arises no question of continuation of the appellant's mutation
So-
dated 19/3/2004.
So the Board of Revenue goes into the facts of the title of my vendor.
Correct. It can
Correct.
go. It's a
Yes.
revenue court.
Yes. And thereafter, but the Revenue Board has missed one legal aspect. His name was mutated with the consent of Pattadars, my lord, as per Rule 122 of the Assam Land Regulation, with the, except this respondent number 3.
Because
with
there
the-
is no entry showing that the land is valued at less than rupees 100.
No, that is it. 122, my lord. The 122 of the regulation says that if the Pattadars agrees, then the name may be entered into the records. It is the only mutation entry, my lord,
When
not question of the title. They
no,
entered.
but here it's a change of title. Where that can happen is supposing you A and B are brothers. They give a consent that okay, I will take 1 katha, you take 2 katha, and then they come and make an entry. It's a division between the two. But after the Registration Act, which has come in, the value of registration being more than rupees 100 has to be compulsory
My
registered.
lord, corrected. The legal proposition, I cannot dispute it.
So
Here
therefore,
there is two deed owner. Here there is two deed. One is at the consent of the Pattadars, this where this respondent
this-
number 3 belongs.
but this
Now
can,
another land, this is another brother's land. This Virajan Hussain, he also sold 1 biga 1 kata 6 lucha.
that's what we are asking you. You see, once the transfer is made and there is a chitta entry under 122, as you are saying, we accept it for the time being. But does that say that the value of land, because this is a transfer being more than less than rupees 100 is not required to be compulsory registered.
No,
That's the only exception.
Section 17 is there.
So to overcome it, we don't find a legal flaw in the finding of the learned Board of Revenue.
Now, Board of Revenue was committed, with all respect, my lord, with all respect, that there are two deeds. And there are 2 persons were executed. There are 2 owners. Now, this respondent belongs to one branch. Now, another branch, there was no objection. Now, the Chitta's entries was on the one part. And another part, another branch sold out to Manohar. And then Manohar name was entered. And Manohar, we verify the land records. We find his name is mutated. And accordingly, he transferred the mail against the consideration. So my 2 sale deeds
But
are.
what happens to the interpretation clause, section 3? What happens to that of Transfer of Property Act?
My lord.
What happens to that? Just give me Transfer of Property Act. A person is said to have notice, section 3.
Yes.
How do you interpret that? Because if a person's name is entered,
My lord.
the consent of all the Pattadars were not taken. So
As
therefore,
per Chitta, there's consent is there. As per
consent
Chitta.
of
Their
all the
names, they signed on the Chitta. Yeah, yes. Later on, they revert back, but the record says, my lord,
They appeared before the Board of Revenue
No, no,
by filing an affidavit.
this is they, by their affidavit, they challenge. Consent does me. Chitta. Let me sign it. ADC order, please. It's reflected in the ADC order, page 84. 84. अरे भाई कोर्ट আছে Page 85, my lord.
You see, that was intriguing in the mind. We have the trial court records with us. The order of the ADC.
Yes.
Additional Deputy Commissioner Revenue. I'll just read one line. So one paragraph, in fact.
It reveals from the record.
The Chitta copy annexed with the report
Yes,
reveals the same fact. Similarly, Chitta mutation order passed by the circle officer,
yes, not looking for.
North Lakhimpur Revenue Circle dated 13/8/2003, wrongly mutated the respective share of serial number 7 and 11.
Oh, yes.
That is share of Inamul Hussain Hazarika and Altaf Hussain Hazarika to Sri Manwar Ali, which is in contravention with the revenue rules in force. Further, as per the existing rule on the Transfer of Immovable Property Act and Indian Registration Act, the purchase should be through a registered sale deed only. Records also indicate that the land in question exists within less than 3 kilometers from the municipal boundary. Hence, Chitta mutation order passed by so-and-so is set aside. And Chitta mutation was held to be illegal.
That is there, my, in the order.
So if that goes, you'll have to try your luck in the civil suit. You'll have to.
Our contention is that we are in possession. Now the question is that regulation 41 would come. Now, if the person not in a position, then they should approach to the appropriate firm. We are in possession.
Have to go.
We are in possession.
In a writ court, we can't declare possession.
No,
Declaration of possession can't be given.
That's fine. But regulation 41 not considered by all throughout.
We will not consider that. You see, the simple reason, we are just, because of the facts, unique facts in this case, instead of first hearing you on merit, we are just trying to identify the suit land first.
Right.
With descriptive boundaries. And then we find that there's a mismatch with regard to the boundaries given. Then you say that the mismatch is because of the fact that those entries are not, the vendors' entries were not there, but they gave their consent in the Chitta. So therefore, we are trying to find out from the Chitta, because what happens is that we are referring to this Transfer of Property Act.
My lord.
Transfer of Property Act, you see the interpretation clause 3.
We notice, my lord.
Person, person said to have notice.
Notice.
And this notice has been interpreted in a very recent decision of 2025 that this notice must be, it may not, cannot be presumed. Three-judge bench now is interpreted saying that to have this notice means this notice must be matter of fact, not a matter of presumption.
Fact, what said?
Prior to this judgment in 2025, last month it has come to my notice. When it was passed, I don't know. So it says that there's a shift in the approach of the Supreme Court of India, and now it says that it can't be by presumption. All other judgments is on the basis of Section 5, which has been interpreted that one will have presumed to have notice. That presumption has gone. So if that presumption is not there and if there's a finding of fact, please tell us in a appellate jurisdiction, can we examine facts and then give a finding?
I'm
contrary to-
not on that, my lord. My only contention is that we cannot go into all the facts before this appellate court. My only contention is that the entire land we claim by two sale deeds, that sale deeds is still alive. It's a registered document. Unless it's cancelled, it follows mutation. My sale date follows the mutation. Mutation not followed my sale date.
No, you see, I'll tell you, I'm good in telling horrible stories. Miss Gohai executed a sale deed of Taj Mahal in favor of Mr. Sharma. Am I aware of it? Her sale deed of Taj Mahal is in favor of Mr. Sharma, and I am aware of it. Now, please tell me, even if this sale deed is valid or invalid, I have a simple question. Will Mr. Sharma become the owner of Taj Mahal?
It is not permissible under law. Being a purchaser, my lord, I have to see the revenue reports, I have to consult the revenue reports. I have to see, and then thereafter the due permission was granted by the competent authority. It is not, because so far the Rashtrapati Bhavan, I cannot purchase, there is no permission.
No, you can purchase, you cannot get a title, but yes, you
No,
can still
no, I
purchase.
cannot purchase, my lord. I cannot obtain the permission, my lord. Because the lordship is also aware the permission is required. The
No.
competent authority has granted the permission.
Correct, but you see, the basis of your title has been taken away by the ADC revenue. That
He cannot, my lord. He cannot go into the title. That's my contention.
That's the beautiful way of writing this judgment. He doesn't go to the title.
No, he
just
says
says
vendor's title.
yes. He says that it is not found and therefore mutation is cancelled.
So that
He has not declared title.
no, he
Declaration of
cannot
title is
touch,
not given.
he cannot touch into the question of title. He only to be concerned
He has not done
in
it.
respect of possession, my lord.
He has not done it.
No, this is incorrect. My respectful submission. The learned ADC only
Please tell us, ADC revenue while sitting in the court as a revenue revenue authority, is he a civil court?
No, man.
Yes, it is.
No, he cannot
You-
go. Our division bench judgment,
No,
my lord.
that is one part. But a revenue court is a civil court, and that you will find in the book of Justice K.N. Saikia.
So, okay.
He has given a elaborate details of why it's a civil court. That has been
My
referred to.
only respectful
That has
submission,
been referred to
lordship
by
will
this
make-
judgment, by the judgment of this court, and it has been held to be a civil court because even the revenue, just for it to, it's a civil court. It's a very short judgment. Hello. See this. We'll take a lunch break and then resume again. We'll take a lunch break and resume again. This is the This is the judgment of this court, where cancellation of a mutation. It says that the court, the revenue court has the power to pass orders.
My lord.
The revenue court has powers to pass an order to cancel mutation.
My lord, that's there. I'll come. What the revenue court powers, how it's confined, what is the parameter? I will just satisfy this on court to my ability.
Mr. Segia? You have to address us on the.
Yes,
other
I have
part
to
and
just
matter.
my closing remarks will be there.
Yes.
And one short affidavit we had filed regarding the curriculum. So that also I will have to place. It will
Okay.
not take more than 10 minutes from, I can wait, Lordship. No
Because this is a part
Yes,
and matter
yes,
going
yes,
on.
yes.
Let
No
wait for
difficulty.
some time.
May I start? Let's start.
Yes.
Yes. So, what I'd like to draw the attention of the court, my lord, that the jurisdiction of the revenue authority in deciding the issue of the mutation, its cancellation, and all consequent effect thereto. The regulation 41 covers this subject matter. So therefore, I would like to request this room, my lord, just to have a look at regulation 41. So that is the jurisdictional aspect of the revenue authority, my lord. So the revenue authority has to confine. Because admittedly, my lord, wrongly or rightly, there is an entry in the revenue records. Now, the effect of the entry, regulation 41. Page 16, perhaps this book is A.K. Banerjee's book. Lordship has got. May I read? Entries in the record made under section 40 shall be founded on the basis of actual position, and all dispute regarding such entries, whether taken up by the settlement officer or of his own motion, or on the application of the party concerned, shall be investigated and decided by him on the basis of an all person not in possession, but claiming the right to be so, shall be referred by him to the proper. So therefore, my lord, my respectful submission is that the revenue court has to decide who is in possession.
Please come to section 39, which regulation of section 39.
Subject to the provision of section 151 of this regulation, the order of the settlement officer is to the person to whom.
No, before that, I was interested in that part D. Heading is record of rights.
Part B.
Just before 39.
Just before 39. Part 39 starts is part D.
Part D, record of rights.
Records of rights.
So record of rights includes effect of decision of settlement officer.
17.
17. Yes. Records of right. The settlement officers are framed for each state of it.
No, I'm more interested in that only heading. heading is record of rights,
my lord.
correct? And 39 starts with effect of decision of settlement officer and settlement.
Yes, with the settlement.
So this section 41, you'll also find entries in the record made under section 40. Now please come
Yes.
to 40. 40 is record of rights, settlement officer. Correct.
Yes.
So there's a misconception that every entry in the record of rights under section 41 would have a what you call definite value. But this is not a settlement operation. Your vendor's name, how did it enter, was doubtful. So therefore, it was not a settlement proceeding. And therefore, certain settlement proceedings you will find under section 23. Come to 23, you will find that.
Regulation 23.
Regulation 23. Some
Procedural
places
in
it
case
says
of-
section. That's why I say section, it also is regulation.
Yes.
23. Procedure in case of boundary disputes.
Yes.
Correct.
Correct.
So now this is what happens when there is a actual dispute and how a person into possession gets his names entered in the settlement and record of rights. So it says that when it's a settlement operation and somebody is found to be in possession, 23 will show you that if somebody is in possession, that land would be excluded in the demarcation cases.
Correct.
Correct. So therefore, this entry of possession remains paramount in section 41.
Right, correct.
Correct. But the difficulty is that your case is not a case of
No,
settlement
my
operations.
submission is, my lord, my submission is very limited. My submission is it is settled position of law that once a person seek mutation before a settlement officer, there is two in condition he has to satisfy. Number one is title.
But when it is a regular mutation, it's not settlement officer.
Yeah.
Then it is revenue officer
So
sitting as ADC. He will make that, sorry, is the circle officer
circle officer.
who makes that, and he's not sitting there as a assistant settlement officer.
No,
Then.
no. He is performing both the twin.
No, that may be there.
Yes.
But you see, that is why I was showing you part C is under the chapter with a heading.
Yes.
Record of
Assessment of
rights.
land. Yes.
It is in this aspect, section 41 has to be read. 41 cannot be read independent of the heading under which this is bracketed. This section 41 is bracketed.
So my submission, my lord, this two in condition must be proven. One is sale deed and second is possession. Otherwise, the mutation cannot be granted. So there must be a twin condition. One is sale deed and number two is possession. So therefore, when the investigation is to be carried out while deciding that whether the mutation order is correct or not, then my lord, the question of the possession is one of the determining factors. My respectful submission. So therefore,
No, please, I'm just trying to understand.
if
You
I have a title,
you are sitting on a land. You own a land. Maybe it's a tea garden which you own. You may not be in physical possession of that land, but you are owner of a tea garden where you have a lot of land.
my lord.
And some third party executes a sale deed.
Right.
And somebody takes possession. How will possession be paramount? This is not a settlement operation.
Without possession, my lord. Now the partition, if I am the imperfect partition, there is twin condition. I must be in actual possession. And also
With a valid title.
So therefore, without possession, I cannot seek a partition also under section 97.
But
Similarly, my lord.
will it be without title, without a valid title? Can that happen?
No, that I am not arguing. My argument is that the revenue officer should also investigate that who are in actual possession, which is absence in this entire proceeding, my lord. Neither the ADC has gone into that aspect.
That will only come when you file an application for boundary determination of dispute, which is within the scope and ambit of section 23. Exercise of what you call the possession in other cases is only a prima facie satisfaction that where they write Khorida Dakhala Hotre. এর নাম নামজারি করা হল।
Correct. Correct.
And খরিদা দখলা হতে is not a prima facie evidence of either title or possession.
No, not when it's a dispute, my lord. When a dispute arose in respect of the title or in possession, then the civil court will determine it's a settled position of law. And one judgment about the single bench in 2019, referring this Urmila case, my lord, which my lord has pointed out, in that case, the single judge has decided that the one, wrongly or rightly, the title has acquired. Now, therefore, the question has to be decided by the civil court. Here in this case, my lord, the facts remains, I'm just saying now within a minute, I'm just narrating the fact. The one unregistered sale deed, on the basis of that, the petitioner has recorded his name mutated in the records. Now, thereafter, after the death of the original pattada, the legal heirs has challenged. Then the revenue board has cancelled the mutation. Then came before this honorable court, my lord. Now, paragraph 5, my lord, kindly have a look. Paragraph 5. Considered the submission of the learned counsels. From the submission of both the learned counsel, it is evident that the dispute prima facie has arisen with respect to both possession and title of the suit land. Granting of mutation cannot endow any persons with the title with respect of the land on which his name is mutated. But as there is a dispute where one party is claiming the land purportedly sold to him, here we are claiming, my lord. And on the other hand, the other party is disputing about the sale. A duty was cast upon the learned chairman to refer the parties to get a declaration with respect to the title of the land from a competent civil court, which the board did not comply with. Such claim and counterclaim is sufficient to form a cloud over the title of the party, claiming bona fide the ownership title over the land. So a declaration of title from competent court is necessary, which is sufficient to grant mutation of the party in whose favor the title over the land is decided. This court in Urmibala Das and such, while deciding as to whether the suit in view of the remedy provided under section 53A2 of Assam Land and such is maintainable, held that the regulation has given a right to a person to cancel a mutation obtained illegally, but that does not mean that a civil court shall have no jurisdiction to give a declaration with regard to that. Instead, by way of the impugned judgment and order of the learned chairman exceeded his jurisdiction by holding that the case is of a nature of the land grabbing, etc. Now, Lordship, kindly have a look at para 6. The provision of land grabbing, this is not related to us. Now, next page, my lord. Having not done so, the considering the nature in dispute between the parties, the judgment and order dated such and such is set aside with a direction to the parties through this petition, more specifically the private parties, to approach the appropriate forum for declaration of the right title. So my humble request, my lord, and my humble submission is that since the possession was not addressed by all the courts below, my lord, the matter is to be remanded back to decide who is in possession. Because possession is, so for the mutation is concerned, one is the important pillar to decide, my lord. And with that tune, earlier we referred to a division bench judgment, my lord. That also speaks about the same ratio. So wrongly or rightly, I got the title, my lord, and my name was mutated. So the question is, my lord, whether the revenue officer having any jurisdiction to touch upon the title or not, and also to decide who is in possession. So that part, the second limb of the requirement of the jurisdictional part, that was not addressed, my lord. So therefore, my humble submission that all the courts below, starting from the additional deputy commissioner to board of revenue and the learned single judge, that issue was not addressed. So, Lordship may either of the way dispose this appeal, my lord, to direct the revenue authorities to decide this point, who is in possession, and decide in accordance with law. Because it's a difficult on our part, my lord, this Reed court cannot decide on the question of the possession. There is a pleadings of the parties during this during the proceeding, my lord, so far the possession is concerned. But to decide the factum of the position, it is difficult on the part of you. I do agree with it. So therefore, my humble submission, my lord, this should be some court, that to remand the matter, my lord, by setting aside all the orders challenging the position of court, to decide the position and then decide the question of the mutation in accordance with it. But without possession, they cannot claim the mutation. And my position is also supported by an title registered deed, whether it's illegal or legal, that cannot be questioned or decided or adjudicated by the revenue court. This is my summary.
Yes,
And
please
so
go
far
ahead.
the Urgibala case is concerned, my lord, the recently two judgments of the Supreme Court, in 2024 judgment, in respect of our High Court judgment, my lord, that whether in spite of section 97, whether the civil court having a jurisdiction or not, our High Court says that the section 97 bar. So therefore, the matter went to Supreme Court, and recently Justice Padiola, authored by the judgment, said no, the civil court has no jurisdiction. That I am cited. I'm not print out getting the print out. I was giving a citation. 2024 SCC Online Supreme Court 3845. 24 SCC Online Supreme Court 3845.
3845.
3845, my lord. Decided on December 2024.
Name of the parties?
Party's name is Abdul Razak Laskar versus Mafijur.
How is spelled?
ABDUL, my lord.
Yes.
And Razak REJAK. Laskar LASKAR. Is arising out of the one second appeal by this honorable court. May I conclude, my lord? If any queries, I will.
Okay. Yes.
My lord may be pleased to peruse. My lord has already seen the order of the Learned Board of Revenue at page 101, the type copy of which at page 94 of the appeal memo. My lord, here at para number 10, my lord has already gone through that the court has cleared that with regard to documentary proof that how Late Manohar Ali became the owner of the total land. The total land of which is also in a dispute, my lord, because neither the Sitha copy was produced by the appellant's hearing before the Learned Board of Revenue and before this single judge also, my lord, neither annexing along with this petition. So with regard to the total land, there is the dispute, my lord. And my lord, since the ownership and my lord, the mutation of the vendor, my lord, is not clear and not correct, my lord. As such, they cannot claim the mutation on a wrong basis. Moreover, the mutation, my lord, on the basis.
But that summation of yours
Yes,
is not
and pri-
acceptable.
Yes,
That summation of yours is not acceptable because of the fact that in the order of the additional deputy commissioner,
my lord.
he has mentioned that he has gone through the records and he has seen the Chuta mutation orders.
Yes, my lord. In which, my lord, two of the persons, my lord, be pleased to peruse, in which, my lord, they have stated that the all, my lord, the Nane additional deputy commissioner, my lord, it has been stated that, my lord, if, please, my lord, in favor of, so, became in, my lord, he has seen them, yes, my lord, with regard to that Sita mutation, it has been referred at page 85, my lord. My lord, may kindly see at page 85, it also reveals from record that out of 8 co-porters, only 6, my lord, yes.
Page 85 you are referring to.
My lord. Page 85 is the, okay, my lord, the 85.
Uh, just come to page 86. How that part of the order is sustainable? Which is that provision?
My lord, with regard to in this report, my lord.
It says that the sale in this report, but the deeds were executed before the expiry of mandatory period from the date of mutation. Now, where would you find this provision?
With due respect, my lord, my lord, that part also, my lord, this paragraph is a continuation of the earlier paragraph, my lord. There are two grounds discussed, my lord. This part is second part, and the other part is also with regard to the consent of the all co-pattadars, my lord.
That's okay. There's one part.
One part,
There's one part.
yes, my lord.
But the second part, where is that provision? In fact, I am not aware of it.
This, my lord, I. And my lord, my lord, the sale deed which has been reflected, my lord, those were executed on, my lord, it is of 2003. And the name of both the vendor and the appellant's hearing, the names were recorded in the year 2005 on the same date, my lord. They were recorded on by an order 36/2005, my lord. They were recorded in the Jamabondi, my lord, on the name of the vendor and the appellants, my lord. On the same date, they were corrected on 3/6/2005, and the sale deeds were executed in the year, my lord, on 2003, my lord. And so section 50 says about registration, my lord. My lord, with recording to the names of the Jamabondi, my lord, they recorded a corrected, my lord, on the same date, the vendor and the appellant on 3/6/2005 in the Jamabondi, my lord, and the sale deeds were executed in the year 2003, my lord. They were prior to the name or recording of the name in the Jamabondi, my lord. How do you,
Please repeat it.
my lord, the name of the appellant and my lord, the vendor of the appellant are recorded in the Jamabondi on the same date, 3/6/2005, my lord. My lord, may
Which page?
69. 69 at right column, serial number 6 and 9, my lord. Page 69, type copy, my lord.
Yes.
Serial number 6, my lord. As per order dated 13/8/2003, passed by the circle officer, the name of Manwar Ali, that is the vendor, son of Amu, has been mutated and corrected in place of Patadar des by virtue of purchase and possession. My lord, may kindly see this purchase and possession in respect of the land, my lord. It was corrected on 3/6/2005.
Yes.
And thereafter serial number 9, my lord. As per order dated 19/3/2004, passed by the circle officer, the name of the, my lord, this is the appellants. The appellants has been mutated and corrected by virtue of purchase and possession in respect of land measuring 2 bigha 2 katha 12 lessers out of total land measuring 5 bigha 1 katha 8 lessers and the dark number 146 1. They were also corrected on the same day, 3/6/2005, my lord. Both the name of the appellant, the vendor of the appellant were corrected on the same day, 3/6/2005, and the sale deeds were executed in the year 2003, my lord. And my lord, one more submission, my lord, as per the contention of the appellant from the circle officer TD ADC Board of Revenue, their contention was as per gift, but here it is reflected purchase and possession, my lord. Khoridi dokholi hutre, purchase and possession. And their contention was that one part they have purchased, the other part was gifted. It is not even clear which part was gifted and which part was in possession, my lord. And as per the revenue record, Jamabondi, which is prime while any registration is done, my lord, here it is recorded later on, my lord, and we reflect purchase and possession, my lord. And my lord, out of the pattadars, some of the pattadars have even filed an affidavit before the Board of Revenue stating that no such gift was even done between the vendor, my lord. They approached the Board of Revenue by filing affidavit, my lord. So, and my lord has already gone through the paragraph 94, paragraph number 11 of the Board of Revenue, my lord. It has been clearly stated they have filed a review, which was also rejected on that get. And my lord, I like to place, my lord, the impugned order, my lord. There is no infirmity, my lord. As impugned order, lordship, page number 151. The impugned order, my lord, it is, my lord, may I read?
Just a moment.
151. The impugned order of the Honorable Single Judge, my lord. That paragraph.
Just a moment. Mr. Datta, in this same context, which he is referring to page 69, where are the reference to two sale deeds in which remark is the reference to two sale deeds?
Yes.
One thing I just clarify, my lord, my learned sister is saying that this correction is on the same date. Lordship is well aware than me, your lordship, that what is the earlier, there is a procedure that after the mutation, my lord, what I understood and I have seen also in the law. After the mutation, the record was the cheetah is kept in the office of the circle officer. The Jama is in the office of the deputy commissioner. What happened earlier? That the first cheetah was corrected. Then all those cheetahs, they were taken by the Kanangu in the office of the deputy commissioner, and then the Jama rectified. So therefore, this later on, this 3/6/2005, that was corrected the Jama only, not cheetah. And in both sale deeds, my lord, the land permission was granted by the deputy commissioner, land sale permission. So therefore, it matched with the cheetah Namjan, cheetah's name and entry in the cheetah. So we should not, my lord, confuse, because this 3/6/2005, it is a K. Shoikia is my signature. That is the correction of the Jama in the office of the deputy commissioner. It is not a cheetah. So both the records, 2003 and 2004 records, all taken together and rectified on a single day. That there is a possibility.
There is no such possibility. Because then what is written in the remark column of the Jamabandi is that in terms of order of so and so in the cheetah mutation, the records stand corrected accordingly. It will never be, an entry will never be as per order dated so and so of the circle officer, the so and so has been mutated and corrected by virtue of purchase and possession. This is purchase and possession is an original entry. It's not a rectification order.
No, I'm not saying so, my lord. I'm on the SD case Wikia 36/2005.
We understand that, but then it will always be the Jamabandi is corrected as per the Chitta record.
Yes.
It will always be a correction of the record.
And that-
Correction of record is not found here.
No, that is not reflected. That is not reflected, usually not reflected. But if I produce the Chitta copy, Lordship will find that the entry date is prior to 2005. Otherwise,
Maybe we will not examine the title right now.
yes, no. I'm just clarifying. It's not our issue also.
I've been doing it for last 25 years.
Yes. That's why I say, my lord is.
But where is the second cell deed referred to in this Jamabandi?
NHR
Jamabandi cell deed is not.
51 and 60. Page
Huh?
number 51 is the first cell deed.
No. In the Jamabandi, where is these two cell deeds recorded?
That not, the number is not here.
It's not there.
No.
Is there two entries of two different cell deeds?
No,
No.
single entry,
Single entry. Okay.
single application.
Okay.
Is apparent here. Because that original order we have not in custody.
Yes, Ms. Gai, you were saying something.
My lord, I take your lordship for a second to page 151 of the impugned, my lord, the impugned order of this single judge, my lord, paragraph number 10. So may I- My lord, after hearing the learned counsel for the parties and on perusal of the materials on record, including the order of the additional deputy commissioner and the impugned order of the Assam Board of Revenue, upholding the view of the additional deputy commissioner Lakhimpur, these court is of the consider no legal no apparent infirmity or illegality appears from the said order. The learned board, in fact, have discussed in elaborate details both the facts and the law holding the field, and since the very fact of how late Monorali was based, the right title and interest of the property in question was not proved in a competent court of law. This court does not find any order in interfering with the order of mutation passed in favor of late Monorali, and therefore in favor of the present petitioner. This court also find force in the contention of the learned state council that as a court exercising its power under Article 226 of the Constitution of India, it is only the decision-making process which can be the subject matter of scrutiny, and in this case, the decision appears to have been arrived by taking into consideration the relevant facts and circumstances and by application of mind. My lord, my submission is that from the very instance, my lord, the total length with regard to which the dispute has started, my lord, that has not been clearly, because their claim is purchase and gift. And from the very starting onwards, it is completely with depend on purchase and possession of Manwar Ali. My lord, Manwar Ali is a vendor from whom they have purchased. Since the title of the vendor is not there, my lord, it can be transferred to different persons with time, but that will not give any right or base about anything. So the competent court to decide with regard to any issue, if so sustained, is the honorable, is the civil court, my lord. And neither of the courts has touched the title of any of the persons. It has only gone to with regard to the legality and illegality of passing the mutation order, my lord, which is correct, apparently correct in the eyes of law, my lord. Well, the title is not being touched, my lord. And the appellant are standing on the footing with regard to the sale deed, with regard to the possession of Manwar Ali. And Manwar Ali has, as per them, purchase and possession, my lord, it is not gift. And moreover, the Pattadas have given the objection before the Board of Revenue. They were not made party in this petition, in neither in the single judge, my lord, neither before this appellate authority, my lord. Just my humble submission is that this honorable read court cannot go depth into the details of each and every document of the sitha of the title, which are even not in record also, my lord, annexed along with this Hill memo, my lord. And it is the jurisdiction of the civil court to look into detail with regard to each aspect, with regard to possession and all those other aspects, my lord. So my humble submission is that the learned ADC, my lord, the Board of Revenue and the Honorable Single Judge has rightly passed the order, my lord. It's my submission, my lord.
Right.
Mr. Datta, we're just telling you what I'm telling you is what I got it. Correct. The two cited at page 51 and page 60. I have made a boundary of this the two land. The two land seems to be unconnected. We'll take it, one is A, one is B. North in one
Not
cited is
contiguous.
Ujala.
Not contiguous.
I don't know, page 51 I am saying, I won't remember what. Page 51, north is Ujala. South is SHA Begum. East is Jogen. West is Nazrul.
I noticed, my lord, it's
And in the second, it just doesn't match.
yes,
Correct. So
Correct.
it's two independent and still it can't be reconciled.
you correct me. My lord says.
Still it can't be reconciled. There's no common,
There is some, there is
there's no connectivity, because you see in the second sale deed, you have written left is purchaser. Sorry, west it is purchaser. Second sale deed is not by the purchaser.
There is something that we cannot answer because it's not on the record, my lord. But on the lighter mode, my lord, after receive, because the client, respondent number 3, my sister's client, she is the wife of Manohar Ali. So both of them receive the money, and then through respondent number 3, now we are in trouble with.
Can't comment.
You don't like how on lighter movement.
You can't comment. We'll just examine the records and
My
file
lord.
orders. The submissions of Mr. Bhaskar Datta and senior counsel, assisted by Mr. S. Datta and counsel for the appellant, and Ms. S.G. Barwal and counsel for the private respondent, and Mrs. S. Sharma and government advocate, 1, 2, and 4 have been concluded, judgment reserved. Mrs. Sharma, anything you have to say, because we've said we have heard you.
Yes, well, I stand by the judgment of the Honorable Senior Judge.
Okay, good.
There's no infirmity in the process.
No, but it's just to make the record straight. Since I have said I have heard you,
Yes.
I must hear your voice.
Correct. Thank you. Grateful, my.
Obliged, my lord.
The Advocate General is here.
Yes, my lord, he's coming, my lord. Coming, my lord.
Time being item 7.
Mr. Chaudhary, before the Advocate General begins, he had referred to filing of an affidavit. You've gone through it. You
Yes, my lord.
want to rebut it or no?
My lord, we don't want to file anything.
Okay.
In fact, my lord, when the Advocate General has already almost completed, I'll also take 10-15 minutes. ma'am.
No, it's not that, because since he is referred to an affidavit, I'm
Yes.
just asking you whether you want to rebut it,
No.
because that's your right. I have to ask you. Yes. No, because since you referred to an affidavit, I just asked Mr. Chaudhary whether he wants to rebut it.
Lordship.
That's
So he's no declined, lordship, no difficulty, lordship. So in our affidavit, we have basically said that because they have taken several grounds. One of the ground or limb of argument was lordship. According to clause 4B, annexure of the notification of 7/11/2023, prescribing minimum standards required is applicable only to institutions applying for opening new allied health science pharmacy institution.
you're reading when?
No, I'm reading their points which we have
Oh,
noted.
acha, okay, okay.
The appellant being a existing, there is no requirement of an MU. That is one limb of argument, and another limb of argument was that clause 4 of the approval process of academic year 24-25 provides that MOU with hospital is required only for Pharm D course and not D Pharm and B Pharm courses. So in our affidavit, we have annexed the curriculum of these courses where there's a specific mention 347 in serial number 5, duration of the course
347.
347. This is D Pharm course. So according to them, D firm, they don't need practical classes. So in duration of the course, it is very clearly stated in clause 5, Roman 1, not Roman, normal 1. The duration of the course shall be for 2 academic years. Each academic year shall be spread over a period of not less than 180 working days. In addition, there shall be 500 hours of practical training spread over a period of not less than 3 months.
I'm sorry, 347.
347, 3. In the affidavit, the additional affidavit which we have filed,
Affidavit, yes. You are reading paragraph?
serial number 4 and 5, chapter 2.
No, I think there's some mistake.
It's the annex.
I think that is page 369.
In my
It's chapter 2.
chapter 2.
2 is Farm D regulations. Part
D
of
form. Yes, Lord.
Farm D regulation.
So it is written as diploma in pharmacy part 1 and
No, we
part
don't know. Page 368 says Annexure B reads Farm D regulation 2008.
So I'm not on that, Lord. There must be some mess up.
He is relying on this, in his affidavit, additional affidavit file of 347.
Annexure B.
Annexure A. Annexure A, 346 page number.
Something wrong.
The additional affidavit which we have filed on 11th. 11th of file. Dr. Anup Kumar Burman's affidavit, DME. Edition.
Annexure B.
no,
Annexure A.
Annexure A.
Annexure A.
It's a pharmacy council notification.
Yes, that notification.
So this is
9th October 2020.
This is page 416 in our brief.
October 2020. Have Lordship got it?
Yes, 9th October 2020.
Yes.
In our brief, it is page 416.
There is a mistake in the pagination
It's
on
okay,
our
it's
part.
okay. It's okay.
Yes,
We are not on that.
Yes. So in this notification issued on 9th of October 2020, if Lordship is pleased to come to the next page, chapter 2. Diploma in pharmacy, serial number 4.
Yes.
Duration of the course, because they are applying for D firm course, Lordship. Only D firm. Number 1, the duration of the course shall be for 2 academic years. Each academic year shall spread over for a period of not less than 180 working days. 2, in addition, there shall be a 500 hours of practical training spread over a period of not less than 3 months. So this practical training they have to take in some hospital. If they have their own hospital, they can get it done there. Or else if there is no hospital of their own, they can have a MOU with any civil hospital of the district. So at present, Lordship, that is not there with them. So the submission made by them may not be correct. In fact, it is not correct. If you look at the syllabus issued by the Pharmacy Council of India. So for this purpose, Lordship, we have brought this additional affidavit. So this MOU with a civil hospital is required not only for the present situation under the new regulation or new guidelines framed in 2023, but when they first obtained the NOC, there itself, it was there. If Lordship is pleased to come to page 60 once more. In fact, I have already placed it. I am just summing up my arguments. So page 60. On 3rd June 2022, NOC was issued to them, NOC for starting degree and diploma in pharmacy course in private institution as applied. So it was given by the Joint Secretary of the Government of Assam Medical Education Research Department, and it was issued to M. Hawk, Chairman ERDF and ATCP Guwahati, and Chairman of the Foundation. So if Lordship is pleased to come to the conditions, serial number 6, page 61. The institute will furnish an agreement with the affiliated parent hospital for clinical exposure, that is for practical classes, as required, which will clearly state that such an agreement will not exceed prescribed students patients ratio in order to avoid overcrowding of hospital, which in turn may lead to inadequate clinical exposure of students along with the deterioration of the care. The document will be furnished to government within a month of issue of the NOC to the state government with copies of DME and university. So it was a condition required when they started it, when they first got the NOC. It was for a limited period, that is over. In the meantime, the NOC, which was given for 5 years time, it was 2 years time. Then they got another one, but it was cancelled, and till now they have not challenged it. That was cancelled on 11th of July 2024.
This page 60.
No, this is not cancelled. The cancelled one is that in the MOU, the cancellation order, which was not part of the writ proceedings, 51. But in the review application, it was recorded in the original judgment of the learned single judge. And even after considering that also, the learned single judge said that they have fulfilled all the requirements so far as infrastructure is concerned. On that point, in paragraph 21 of the judgment, we have filed a review application, and that was allowed because the learned single judge duly considered that the MOU is no more in existence. Still, the learned single judge opined that they have fulfilled all the criteria and parameters of infrastructure in the institution. So the learned single judge was pleased to correct the mistake that had crept into that order. And against that order, this writ appeal has been filed. Lordship, in this case, whether the order of cancellation was right or wrong, whether it is a valid order, invalid order, that is not the subject matter. The subject matter is very clear.
Please take us back to that order where this MOU was cancelled.
Yes, I'll just.
Page 51B.
Page 51B.
51B.
11 July 2024. Issued by the Director of Health Services, Assam. To the Joint Director of Health Services, Karimganj, because he was one of the signatory of that MOU. Regarding cancellation of MOU signed between Karimganj Civil Hospital, Karimganj, and Alama Tier College of Pharmacy, Badarpur District, Karimganj. I have been informed that a private pharmacy college, namely Alama Tier College of Pharmacy, Badarpur District, Karimganj, had signed a MOU with the Superintendent of Karimganj Civil Hospital, Karimganj, for facilitating hospital training, clinical exposure of B Farm and D Farm students. However, it has come to the light that agreement of MOU was signed without taking prior NOC approval of the higher competent authority / government, which is stated to be in gross violation and breach of office procedure. In the light of above, and in pursuance of government notification dated 9/7/2024, the MOU of Memorandum of Understanding signed between Alama Tier College of Pharmacy, Badarpur, and Karimganj Civil Hospital, Karimganj, is hereby cancelled with immediate effect. Therefore, you are requested to take immediate necessary steps for cancellation of the MOU from your end. The action taken report on the above matter is to be intimated to the office of the undersigned at the earliest for onward submission to the government. So on the basis it was cancelled. Next page to cancel for us. Next page is the cancellation order by the Superintendent's Karimganj Civil Hospital. So instantly the government's order was complied with. And till now, neither of this 11 July or 12 July's order are put to challenge before any forum. Just submitting during the course of hearing that this is not correct, this is a arbitrary action, this is an invalid order, all these things will come up as and when a proper challenge is put against these two orders. Then we'll come up with our defense. But as on date, both these orders are in force. And the learned single judge realized this, and therefore the rectification or the correction of the impugned order of the learned single judge in the writ proceeding was reviewed. So their submission that in the existing pharmacy institutes, there is no requirement of any MOU with a hospital under the regulations framed by Pharmacy Council or under notification of 7/11/2023. This submission, in my humble submission, is not acceptable because whether it is 7/11/2023's notification regarding the new guidelines or the guidelines which are in force prior to the issuance of the new guidelines on 7/11/2023, in both situations, practical classes are contemplated in the course. It's a part of the curriculum. For that, MOU or an existing hospital must be there for due exposure for practical classes of the students. So far as this particular course, whether it is D-Pharm course or the higher course to D-Pharm also. In both situations, it is mandatory to have the hospitals. If it is they are not own hospital, self-owned hospital, then it should be there should be a tie-up with a government hospital. So in both situations, it is a mandatory condition that cannot be diluted or that cannot be waived.
Both conditions you are referring to 7/11/23 guidelines.
No,
And,
no, 7/11/23 guideline says it must have. Number
and
one.
the second one?
Part one, that 2022, that NOC which I have read out, Lordship.
Okay, page 60.
Page 60.
Okay.
That also, that was issued in 2022, prior to the new guidelines. When they started the course, that point of time also, it is a condition precedent in the license or the NOC that they must have it. So as on now, in today's context, Lordship, they do not have this MOU. Suppose they have their own hospital, then definitely they will fulfill the conditions. Or if they can get a fresh MOU with any hospital, then also it is possible. So the learned single judge have rectified paragraph 21 of the impugned judgment. 332. 332. 336. This is the review order. The order which was reviewed, the earlier order is at page 330, paragraph 21. And before 21, I'll just make a mention of page 325, paragraph 12. It starts from page 24. Have Lordship got it? 325.
Just a moment. P25.
325. This is the part of the original judgment at paragraph 12.
Yes, that we have made a submission that this is the recording here and the.
It is a recording here. That is the 9th line from top. Further submission is made that memorandum of understanding signed between Karimganj Civil Hospital and Petitioners College has been cancelled with immediate effect by a communication of 11th July 2024. So this is recorded. And after this recording at paragraph 21 at page 330. 330, paragraph 21. This paragraph is troubling us. It was troubling us, not troubling presently. After the review in our favor, this problem is solved. Paragraph 21, may I read it, Lordship?
Yes, you have already made a note. You have already made a note.
Yes. So Lordship has already made, and therefore I'm just closing my submissions, Lordship. And therefore, by review order at 333, page 6 to 2025, the learned single judge at paragraph 9, after recording all these factual things, at paragraph 9, page 337, accordingly, this court is of the considered opinion that the review petition have made out a case for review of the directions passed in paragraph 21 of the judgment and order dated 16/8/2024, passed in WPC 388. Accordingly, the paragraph 21 of the judgment and order dated 16/8/2024, passed in WPC 388 is modified as under. Now, a fresh paragraph is there. In view of the discussions made herein above, the petitioners are directed to go for a renewal of the memorandum of understanding and or apply fresh before the concerned authority within a period of 1 week from today. In the event the petitioner applies for renewal or make a fresh application for having a MOU, the concerned authority shall ensure that steps are taken and completed within a period of 2 weeks from the date of application for renewal or making a fresh application. Therefore, the respondent number 3 shall revisit the inspection report dated 20/10/2023 by taking into consideration that the petitioner's college has fulfilled all the required infrastructure and facilities to start degree and diploma courses. However, the issuance of NOC shall be subject to production of memorandum of understanding signed between the petitioner's college and any other hospital as specified in the notification dated 7/11/2023. So this is the rectification order, or this is the reviewed order. So in my humble submission, there is no infirmity. There is no infirmity, no illegality in the review order. Review order is done because the learned single judge, maybe our mistake, maybe the court's mistake, Lordship, a shortfall was there. That has been corrected. The law is well settled. I have placed some judgments also on the earlier occasion in the review court, Lordship. If Lordship wants, then I can place that judgment again here also. That review is that Netaji's case, BCCI case. So that paragraph 89 to 92, that Netaji Cricket Club versus BCCI, it is very elaborately done. A mistake can be there of the court, of the judge, of the advocate. In all those situations, review is permissible. 2005 4 SCC, 2005 4 SCC, page 741, BCCI versus Netaji Cricket Club and others. In paragraph 90 says, I'm skipping it from paragraph 89 to 94, all are very important, but paragraph 90 is to the point. Paragraph 90 says that a mistake on the part of the court, which should include a mistake in the nature of undertaking, may also call for a review of the order. An application for review would also be maintainable if there exist sufficient reasons. Therefore, what would constitute sufficient reason would depend on the facts and circumstances of the case. The word sufficient reason in order 47 rule 1 of the code are wide enough to include a misconception of fact or law by the court or even by an advocate. Then also it is an application for review may be necessary by way of invoking the doctrine of so and so, that principle. So in this case, the Honorable Learned Single Judge Lordship realized that the opinion given in paragraph 21 is contrary to the opinion and the observations he has recorded in paragraph 12. Therefore, the Learned Single Judge was kind enough to rectify the mistake, Lordship. So in that view of the matter, this writ appeal, Lordship, does not have any foot to stand and therefore is liable to be dismissed. Deeply obliged and humbled. Unfortunately, my colleague will be here. My part is over.
My lord, I confine myself to the interim prayer, my lord. Your lordship has already have been very kind enough to, my lord, give patient hearing earlier. And my lord, I'll just sum up. Now, my lord, the order which was challenged in the writ petition, that was regarding, my lord, the NOC was not granted, my lord. The notification dated 17/11/2023, whereby the claim of the petitioners for issuance of NOC for 2023 onwards, that has been rejected. Now, the position of the college is that, my lord, although it was established earlier, for the last 3 years, my lord, we have not been able to take any admission of any students. Now, if your lordship, my lord, and my prayer is at page 208, that is the prayer to set aside the notification dated 17/11/2023, and that order is at, my lord, 292. Your lordship will note, my lord, your lordship has already, my lord, taken note of. Your lordship permits, my lord, I'll read that again, my lord. What are the grounds of, my lord, rejection of the NOC? Whereas Alumma Tier College of Pharmacy under ERD Foundation has applied to no objection certificate from the Department of Medical Education, whereas the petitioner was forwarded, then your lordship is keep third, fourth paragraph, whereas on favor of the institute and on humanitarian ground for future students already admitted, the government issued ex post facto NOC dated 3rd June 2022 to the institution. Then your lordship may come, my lord, the reason for rejection, your lordship will find in the, my lord, last paragraph. Whereas the Honorable High Court in the final order dated 7/9/2023 in WPC 7132 of 22 had directed the department to pass a reasoned order within a period of 7 days from the communication of the modification of the previous inspection report mentioning deficiencies. Whereas the Honorable High Court had inter alia passed the following orders. In view of the above, the authorities in the petitioner to approach the Commissioner and Secretary to the Government of Assam in the Medical Education and Research Department to have precise information as to what is required to be done and what extent the dimension of the laboratories are to be extended, and as an extra space is already available, necessary modification may be done to the building so that the laboratories of acceptance dimension are put in place. The authorities in the petitioner may forthwith approach the Commissioner and Secretary to the Government of Assam in the Medical Education and Research Department, and upon doing the needful, may make necessary modification in the building, and upon the completion of the same, to make a representation to the Commissioner and Secretary for immediate inspection of the space that may be modified, and the Commissioner and Secretary shall do the needful to pass the region order within a period of 7 days from such communication. My lord, I paused it for a while. My lord, the laboratory had 5 square meter less than the required. So, my lord, the wall has been removed, that has been fulfilled. Then, my lord, your lordship will read, whereas the DME Assam submitted an inspection report dated 20/10/2023 of Alama Tier College Pharmacy, Badarpur, Karimganj, wherein DME had opined that Alama Tier College of Pharmacy has fulfilled all the required infrastructure facilities to start a degree and diploma in pharmacy course as per norms, and the government may kindly consider to issue NOC to the Allama Tier College of Pharmacy, Badarpur, Karimganj to conduct B.Pharm and B.Pharm courses. However, it was mentioned that the government in the Medical Education Department, by the order dated such and such that is 31/1/2021, had imposed a moratorium on the opening of new pharmacy institute temporarily till new regulatory framework for pharmacy education is in the state is notified by the government. And whereas the department notified the new regulatory framework on nursing, pharmacy, and allied health sciences in order to streamline health sciences in the state with approval of the Honorable Cabinet on 7 November 2023. whereas all the new as well as old government private pharmacy institutes would now come under the purview of the regulatory norms in order to ensure quality education. Whereas all applications of pharmacy courses under private universities would have to apply afresh in compliance of the norms given in the regulatory framework. In view of the above, after careful examination of the case, the government and the medical education department hereby regrets its inability to grant permission in respect of the petitioners for issuance of NOC for the session 23-24. Now, my lord, for 3 years on this plea or other, my lord, we were not granted the NOC, and finally, my lord, this is the order after the, my lord, earlier round of litigation, and this order has been challenged in this, my lord, writ petition. Then, my lord, in the writ petition, I'd like to draw your lordship attention to certain, my lord, observations of and findings of the honorable single judgment. Then, my lord, I'll come to the order under review. The judgment in the writ petition, your lordship finds at page 123. This is judgment dated 16/8/2024. My lord, by relying on certain paragraphs, my lord, some findings and some observations which will be necessary, my lord, for determining the, my lord, the interim order in the present writ appeal. Your lordship may kindly come to page 127, paragraph 7. May I read it, my lord?
Just a moment.
By reading this, my lord, I want to draw your lordship's attention to the finding that, my lord, for the existing institutes, like the petitioner, there is a time limit of 2 years to fulfill the requirement. That is the requirement of MOU, my lord, that they have been insisting, MOU with our, my lord, hospital.
Yes.
I'm reading paragraph 7, page 127. In the meantime, the government of Assam in the Medical Education and Research Department issued a notification dated, this is 1/11/2023, it should be 7/11, that has been corrected in the next, correct date has been given in the next page. By notification on 7/11/2023 on the subject of regulatory framework of nursing, pharmacy and allied health science sector in the state of Assam, prescribing the detailed norms in regard to the physical infrastructure, academic teaching facilities, etc. for opening new nursing, pharmacy, allied health sciences in the state with a view to develop nursing, pharmacy and allied health sciences in education in the state of Assam and to bring them up to all India standard to produce best quality graduate diploma holders in nursing, pharmacy and allied health sciences. In the said notification dated 7/11/2023, clause 13 prescribes as under. This is important, madam. Existing government and private nursing, pharmacy and allied health science institutes of Assam. All existing institutes having obtaining no national certificate from the government of Assam, offering health education in Assam are required to ensure full compliance with the aforesaid norms within a period of 2 years from the date of this notification, failing which the no objection certificate would be revoked. So, my lord, this clause 13 specifically states that the all existing institutes will have two years time to fulfill the requirement. And this notification was issued on, my lord, 7/11/2023. And therefore, my lord, up to 6th of November 2025, we have got time to, my lord, fulfill the requirement, if any. So we have got time up to November, by. And this notifications period is 2 years. Now, my lord, whether our institute is a new institute or existing institute, my lord, there should not be any dispute, but there is an observation of the Honorable Single Judge also on that. Your Lordship will find that at page 132. No, no, 135. 135. Page 135, paragraph 16. Paragraph 16, my lord, your Lordship need not read entire, my lord. Your Lordship may read from bottom, my lord, 1, 2, 3, 4, 5, 6, 7, 7 lines. May I read it, my lord?
Yes.
The petitioner's college was already granted approval for conduct of first year B Pharm and B Pharm courses for 2020-21 academic session by the Pharmacy Council of India by the decision later dated 10/4/2020. Further, the Pharmacy Council of India by the decision later dated 16/8/2021 had granted approval to the petitioner's college for session 21-22 for conduct of second year B Pharm course and allowing 100 admission for 21-22 in the first year B Pharm. Therefore, the petitioner's college cannot be considered as a new institution in terms of the order dated 31/1/2023 and the notification that is 7/11/2023. So this is a clear finding that, my lord, the Appellant Institute is an existing institute, and, my lord, existing institutes have 2 years' time up to 6th of November 2025 to fulfill any requirement that has been, my lord, subsequently brought in. Now, one paragraph 12, because, my lord, these are the paragraphs which have been subsequently, my lord, modified. If your Lordship permits me, my lord, I will read paragraph 12 also at page 132. Page 132, paragraph 12 is the submission of the, my lord, Standing Council of the Health Department. Your Lordship may skip the first part and come to page, my lord, 133. Fourth line. Therefore, the respondents were not in a position to issue NOC to the petitioner's college and instead instructed the petitioner's college to submit a fresh expression of interest. He also submitted that the petitioner's college had submitted the expression of interest through the Director of Medical Education Assam, which is under process at the government level. Further submission is made that the memorandum of understanding signed between Karimganj Civil Hospital, Karimganj, and the petitioner's college has been cancelled with immediate effect by a communication dated 11th July 2024, written by the Director of Health Service Assam and addressed to the Joint Director Health Service Karimganj and the Superintendent Karimganj Civil Hospital, Karimganj. Therefore, under such circumstances, the petitioner's college cannot be granted NOC until they fulfill all the norms prescribed in terms of the new regulatory framework of nursing, pharmacy, so in the state of Assam, which has been notified by notification dated 7/11/2023. Why I am showing this, my lord? This particular document that was not a part of the pleading or part of the record, but it was not placed before the court during the course of hearing. Now, if your Lordship kindly comes to, my lord, paragraph 16 at page 130 that I have read, my lord. Paragraph 21 is the operative part. Is 188. That is how the writ petition was disposed of. The page will be, my lord, 138, my lord. Paragraph 21. On the MOU, my lord, page 119. Before the, my lord, final order was passed, there is another order which may be relevant, my lord. That is that your lordship it dates at page 119. There where, my lord, this submission was made. Order dated 22/7/2024. Heard Mr. So-and-so. Mr. D.P. Bora, Learned Standing Counsel, Health Department has produced a communication dated 12/1/2024 written by the Joint Director, Health Service and addressed to the Director of Health Services, wherein it is stated that the memorandum of understanding signed between the Alma Tier College of Pharmacy and the Karimganj Civil Hospital is cancelled. That was submitted. Mr. D.P. Bora, Learned Standing Counsel shall take instructions as to on what basis the said MOU was cancelled. The Learned Standing Counsel shall also produce a copy of the order dated 31/1/2021, which is reflected in notification dated 7/11/2023. The court desired to know, my lord, on what grounds it was cancelled, but that, my lord, never came. And, my lord, at page 123, your lordship will find, my lord, the petition number 1, education research is registered at trust, having officers so-and-so. There, my lord, this has been discussed. Now, my lord, your lordship may come to the operative part of the, my lord, honorable single judge's order in the writ petition at page, my lord, at page 138, paragraph 21. In view of the discussion made herein above, this writ petition is disposed of directing the respondent number 3 to revisit the inspection report dated 2010-2023 by also taking into account that the petitioner's college has fulfilled all the requirement infrastructure, because, my lord, that report has said that we fulfill all the requirements to start degree or diploma courses, and the petitioner's college has also submitted expression of interest and thereafter take steps forthwith for issuance of NOC to the petitioner's college and permit the institute to conduct the course of the firm and the firm without any further hindrance. Let such exercise be done and conclude within a period of 1 month. So, my lord, this was the order passed. Now, in the review, my lord, that this has been modified. Now, my lord, I'll make submission on the, my lord, requirement of MOU in the, my lord, notification. If your lordship kindly comes to page 161. This is the, my lord, regulatory framework. And on the basis of this, my lord, our prayer for NOC has been rejected. Now, first sentence will be, my lord, important. Regulatory framework of nursing, pharmacy, and allied health science sectors in Assam. If your lordship, my lord, skips the other conditions, my lord, in the may I read it, my lord? For a third paragraph will be necessary. In the realm of health and education sector of Assam, a number of institutes, both government and private sectors, have been set up to strengthen the public healthcare system. It has been felt necessary to streamline the institutes of nursing, pharmacy, allied health science courses, as there is a wide variation of standards of these institutes in physical infrastructure, human resource, teaching standard, and learning outputs. Therefore, with a view to develop nursing, pharmacy, and allied health science education in the state of Assam, and to bring them up to all India standard to produce the best quality graduates, diploma holders in nursing, pharmacy, and allied health sciences courses, the government of Assam has framed the detailed norm in regard to the physical infrastructure, academics, teaching staff, etc., for opening new nursing, pharmacy, allied health science courses in the state. So, my lord, this notification, this regulatory framework is primarily, my lord, for opening new institutes. This is very clear from the, my lord, this paragraph. Now, your lordship may come to, my lord, page 169. The requirement of MOU. Page 169. Your lordship will find, my lord, this is a part of the, my lord, regulatory framework. I had already shown, my lord, this is for new institutes. Page 169 says, my lord, the detailed norm in regard to physical infrastructure, academics, teaching facilities, etc., for opening new nursing and pharmacy allied science institutes in the state shall be applicable to both government and private institutes. So this guidelines is also for new. And I have already shown, my lord, the Honorable Single Judge has held that it's a, my lord, existing institute. And for existing institute, my lord, we have got time up to November 2025. Then, my lord, regarding the MOU, my lord, at this page itself, your lordship will find, my lord, for teaching hospital, clause 4, my lord, I am reading. Clause 4A is for nursing, B for allied health sciences, pharmacy institutes. The institute applying for opening new allied health science institution must have 100-bedded teaching hospital with X-ray, clinical, etc. This is also for new. Or the institute should have a MOU with a government hospital not below the level of district headquarters hospital for a specific period of not less than 5 years. So this is, my lord, for the, my lord, new institutes. And, my lord, the PCI facilities. And these are, my lord, by the state government, this regulatory framework. Let us also go through the, my lord, the, my lord, requirement as has been given by the PCI, Pharmacy Council of India. That your lordship finds at, my lord, page 42. I'll also argue on the fact that, my lord, for final disposal, whether, my lord, the field already occupied by the Pharmacy Council of India, that can be, my lord, modified by the state government, and that too without approval of the Pharmacy Council. So, my lord, page 42 is the approval process for academic year 2024-25 for pharmacy institutions. My lord, the learned advocate general was referring to, my lord, that additional affidavit that is of 2020, and that is a part of the my petition, so it is already there. But I am drawing your lordship's attention to this requirement of the Pharmacy Council of India. Your lordship may come to the next page, page 43. Clause 4. During approval process for the academic year 2024-25 for introduction of new pharmacy courses by the existing institutions, the institution will have to apply on the portal along with requisite pharmacy education regulatory charges along with GST and submit the below mentioned documents mandatorily at the time of application for consideration of the application. Now for B Pharm courses. My lord, we are offering, my lord, B Pharm and D Pharm courses. Now for B Pharm courses, NOC of the state government is required, but MOU is not required, my lord. MOU has not been stated here. Then, my lord, in case the state government has done away with the issuance of NOC for the state government for starting a pharmacy course, in that case, the institution upload the state communication from the state government. Then for D Pharm, Pharm D and Pharm D post bachelor, new M Pharma course and introduction of new pharma course, consent of affiliation of examining authority, MOU with 300 bedded hospital applicable to Pharm D course. Pharm D is, my lord, my lord, 6-year course. 6-year course. We are not on that, my lord. So for D Pharm course and B Pharm course, MOU is not the requirement of the, my lord, Pharmacy Council of India. So, my lord, for both diploma and B Pharm courses, MOU is not required. But for B Pharm course, NOC is required. And, my lord, if the state government does not issue it, then that should be uploaded in the, my lord, website. That is the requirement. Therefore, my lord, my short submission is that, my lord, firstly, we have got time up to November 2025 to, my lord, fulfill any requirement which is legally permissible that we have. And whether, my lord, MOU is required or not, my lord, that is, my lord, very clear from the PCI, my lord, this for 2024-25. My learned friend is relying on, my lord, old, my lord, document.
No, that is not old. That is the syllabus still going on, my lord. That is the syllabus. On the basis of that syllabus, the courses are going on.
2020.
Maybe, but that is the syllabus on the basis of which the courses are going on, my lord.
Let me complete, my lord. Then, my lord, if your lordship kindly comes to the, my lord, the order in the review petition, I am closing, my lord. At page 332. Relevant, my lord, 336. My lord, I'll read, my lord, from paragraph 8. The court has also taken into consideration that the memorandum of understanding signed between the Petitioners College and the Karimganj Civil Hospital, Karimganj, was cancelled on 11/7/2024, which is also reflected in para 12 of the judgment that your lordship has just seen, my lord, and order dated 16/8/2024. Therefore, while passing the direction at para 21 of the said judgment and order dated 16/8/2024, it appears that this court had made an apparent error on the face of the record in as much as the memorandum of understanding signed between the Petitioners College and the Karimganj Civil Hospital, Karimganj, was not taken into account while passing the direction at para 21 of the judgment. Accordingly, this court is considered opinion that the review petition have made out a case, and then your lordship will see the modified part, paragraph 12. In view of the discussion made herein above, the petitioners are directed to go for a renewal of memorandum of understanding and or to apply fresh before the concerned authorities within a period of 1 week from today. That we have done, my lord. In the event the petitioners applied for renewal or make a fresh application for having a MOU, the concerned authorities shall ensure that the steps are taken and completed within a period of 2 weeks from the date of application for renewal of or making a fresh application. I was here for a while, my lord, while this matter was moved on the first date. My lord, the learned advocate general has made a submission. They may apply, but will not that is be recorded, my lord, will not go, although, my lord, there is a direction in this. Thereafter, the respondent number 3 shall revisit the inspections report dated 2010-2023, that, my lord, which says that, my lord, all the requirements are fulfilled. That is their report. By taking into consideration that the petitioner's college has fulfilled all the required infrastructure and facilities to start the degree and diploma courses. However, the issuance of NOC shall be subject to the production of memorandum of understanding signed between the petitioner's college and any other hospital as specified in notification dated 7/11/2023. Curiously, my lord, in this part, the honorable single judge, my lord, did not specify any time limit. Had the time limit been there, my lord, perhaps there would not have been any occasion, my lord, for coming to review, my lord, on appeal. Now, my lord, my submission is this, my lord. Firstly, my lord, I have pointed out that the order of cancellation of the MOU was not a part of the, my lord, pleadings. Now, my lord, since the court has already issued direction to issue NOC with some observations, we need not challenge the order of cancelling our MOU. Because, my lord, submission has been made that the cancellation of MOU, that is not under challenge. Now, my lord, since the court has already said that we may apply, and, my lord, they'll consider it, my lord, that need not be, they need not deter us from, my lord, compel us to challenge that, my lord. Now, as I have already, my lord, shown to your lordship, MOU is required only for Pharma D courses and not for the B Pharm and D Pharm courses. At page 42, your lordship has already noticed. Now, my lord, one order I'd like to draw your lordship's attention to, that has been annexed to my additional affidavit. Because, my lord, this guidelines, my lord, the regulatory framework is under challenge in another set of, my lord, writ petitions. Although it is an interim order, my lord, that order has not been, my lord, challenged before the, your lordship will find in our additional affidavit at page 341. The same framework is, my lord, under challenge, and there has been some, my lord, interim order. And this is, my lord, in support of our ground number F at page 30.
Mr. Chaudhary, I'm sorry, I'm not able to follow. You are referring to page 313.
341.
That High Court order 341.
My lord.
No, before that you were referring to a High Court order. Which was that?
Yes, my lord.
Which order you were referring to?
Page, the High Court order, my lord. This is the High Court order, my lord. This is the order 341.
341.
It's transact for 341, my lord. Several invoices have come up in the additional affidavit, my lord. Filed on 21/2/2025. Can I get outside there? Get a photo of it.
Yes.
I'm reading only, my lord, 2 or 3 paragraphs from here, my lord. Paragraph 44 at page 358. A glance of the provisions as placed under Chapter 2 of the Pharmacy Act 1948 would reveal that the power pertaining to the courses in the states, as well as the inclusion in the central register, is vested only with the Pharmacy Council of India. Then your lordship may come to the, paragraph 60. Because the provisions have been, my lord, discussed, and thereafter this is the, my lord, observation of the honorable single judge. Paragraph 60 says, may I read it, my lord? At page 363. In view of the said position, and this court, on an examination of the relevant provisions of the Pharmacy Act 1948, having drawn a prima facie satisfaction that the state government is not empowered to regulate the profession of pharmacy in any manner, is constrained to hold that the notification dated 7/11/2023 prima facie appears to be contrary to the provisions of the Pharmacy Act 1948, more particularly when the same does not disclose that the approval of the Pharmacy Council of India was received for issuance of such notification. So that is the notification, my lord. Then paragraph 61. The conclusion as reached by this court with regard to the powers of the state government to issue notification dated 7/11/2023 insofar as it concerns the pharmacy sector was so drawn, basing on a prima facie satisfaction reached upon the examination of the provisions of the Pharmacy Act 1948. However, such a conclusion being a prima facie one and reached only on the for the purpose of consideration of interim direction, would require further detailed consideration upon the respondents bringing on their stand on record in the matter. Then, my lord, paragraph 62 at page 364. This is the interim order that has been passed. And this is holding the field. Paragraph 62 at page 364. In view of the above, this court is of the considered view that that a case for passing interim direction has been made out by the petitioners, and accordingly the following directions are hereby issued. The notification that is 7/11/2023 insofar as it relates to regulation of the education as well as the profession of pharmacy, including the stipulations made therein in clause 9, to hold an exit examination for candidates passing out from the private university in the state and from institutions not affiliated to Srimata Sankardev University shall remain stayed. As a consequence, the direction passed in paragraph 1I above, the notification that is so and so by the University Sankardev University has been, my lord, stayed. Then, my lord, the petitioners exit examination as contemplated as clause 9 of the notification on 21/4 shall remain stayed until further orders. Then others are, my lord, regarding the exit examination. Therefore, my lord, my submission, my lord, to conclude is that, my lord, we have time within their guidelines up to, my lord, November 2025 to fulfill the requirements. And they are stepping into the shoes of the PCI by incorporating these, my lord, provisions. We have lost 3 years already. We have got our staff, teachers, other staff, and they'll be, my lord, rendered, they have been, my lord, in fact, almost rendered, my lord, without any work. And all these 3 years, my lord, on this plea or the other, my lord, some notification comes at some point of time. Whether, my lord, we challenge the subsequent cancellation or not, my lord, we have applied for a fresh one, and there is a direction to consider it. That is also, my lord, not done. On the first day itself said that they may apply, we will not pass any order. Therefore, my lord, since we have got under the, my lord, their regulation itself, that up to November 2025, we have got time, we should be allowed to, my lord, take our students provisionally, till your lordship, my lord, decide the matter finally. Otherwise, my lord, we lose another academic year, and in the month of May, my lord, the admissions start. Other institutes which were, my lord, established with us, who were given, my lord, the no objection certificate along with us in 2020-21, my lord, they are running their courses. And for us, my lord, all on a sudden, they, my lord, cancel the MOU because on the ground that the approval of the higher authority was not taken, that too without any notice. Anyway, my lord, that is not under challenge before lordship. And in view of the, my lord, facts that I have placed before lordship, my lord, that challenge need not be made because my lord, we have got time up to November.
Mr. M.K. Chaudhary, Learned Senior Counsel for the appellant, assisted by Mr. M.J. Kadir, Learned Counsel for the appellant is present. Learned Senior Counsel, assisted by Mr. M.J. Kadir, Counsel for the appellant is present. Submissions of Mr. D. Cycle, Learned Advocate General, assisted by Mr. D.P. Bora, Learned Standing Counsel for the Medical Education and Research Department is concluded. Next paragraph. Submissions in reply by the Learned Senior Counsel for the appellant is also concluded. Judgment is on. Mr. Chaudhary, you and Mr. Bora, any decisions you are citing, please give a list again.
Yes, madam.
Any decisions you have cited, please give it again.
Right.
Just a list.
My lord.
Just the list.
My lord.
List of books which you are reading.
My lord,
Yes.
I have an item number 11. Man is in custody, my lord. He is rising, so my lord. May,
We'll take it up because we'll have not have time. There's single bench to be.
may I pay for listing tomorrow, my lord?
What it will not come. Make it day after tomorrow.
I think
There's one more matter which we had reserved it for taking at 2. Which one?
item 9.
Item
Item 9 also, lord.
9. That also day after tomorrow.
9, 11 also.
Item 3 also. not.
3, 11 and
11, my
11.
My lord, one request, my lord, I'm respondent in person, my lord. Today,
In
my
item
case
number?
17, my lord. My lord, my case was pending from last 3 years, my lord. It never come for hearing. And coordinate bench last on March, they told that today is the final hearing. My lord, I am a jobless person, my lord, and this is
Take it up.
IIT.
Today we have to rise. There's another bench. We can't. Fix it on 29th. We are fixing a matter on 29th.
My lord, it is 2017 years case, my lord. I am
We are listing it at your request. We are listing it on 29th.
29 this month, my lord.
Yes.
My lord, one request, my lord, please place it on the top of the list because 3 occasion it has come to the last
On
of the list.
On the next day, you make a mention. We are not passing any orders to have matters in the top of the list. On that day, you make a mention.
Problem. Thank you, my lord.
Item number 19 and 20. These are also coming for hearing for quite some time. The paucity of time, my lord, can it be
Can't help
taken,
it.
can it be taken on some other day or a fixed day?
It will come. In due course, it will come. Other matters will come because we are updating only those matters where there are.
Here, my lord, it is something related with the composition of the bench as well, my lord. That's why it is coming to your lordship. The division bench 1 is not taking up this matter.
We understand, but you see, here we are also taking up this personal liberty cases where we have to consider bail. Those are taken in.
If a long date, my lord, we are, he is enjoying the order of stay, my lord. I have no difficulty, but if a date is fixed, subject to convenience of your
What is the
lordship.
matter about?
Land acquisition award, he came before the writ court as well as the civil divisional court challenging the award. Composite order was passed.
Only 34 interest, madam, that part, madam.
And there is a
Interest
question of
under section 34, madam, on land acquisition. This plan. That my senior friend may propose in month of June, 10th June, madam. If it is possible, madam.
10th June.
10th June.
Based on 10th June. 2026 as paid for by learned counsel for the, you are for,
I am for the respondent, he is for the appeal.
senior counsel for the respondent. Okay.
My lord, in item number 20, I am appearing for the respondents 1 and 2, my lord.
My lord, he is also respondent, my lord.
Okay. Okay, just say all sides are
Yes,
represented. Okay.
My lord. All right.
Deeply obliged.
Item 1, motion BA.
Your lordship, kindly matter be adjourned for the day. Need may be fixed on 25th of April.
Item number
1,
1. When do you want?
25th of April. Friday.
25th. Okay. List on 25, 4/2025, as paid for by learned counsel for the petitioner.
Item 2, bail hearing.
Item 2, we have prepared one affidavit, my lord, and we'll be filing it by this week, my lord. So can it be taken up next week, my lord? Any date convenient to this honorable court. Next week, my lord, 29 or 30 possible.
You're not saying anything once you're filing it. You see that it will be listed as and when you file your affidavit.
My lord, 29, we'll be filing it 29, my lord, kindly.
So we are not fixing a date because since you have not filed it,
Yes, my lord.
we're just saying that we give you liberty to file it and it will be listed thereafter.
Yes, my lord.
You see, the difficulty is that
My lord.
we have we broke up the division bench to take up single bench matters, and this also is fallen.
Yes.
There you see how many requests were being made to hear the matter. That's the difficulty. Because when somebody comes and says that I am jobless, take my matter.
Yes.
Somebody comes and says I am in the jail, hear my matter.
Yes.
We have adjourned those to take up this matter. Okay. It's M. Chaudhary, learned counsel for the petitioner. The place for leave to file an affidavit. Within a week's time, so prayer is allowed. List the matter as and when the said affidavit is filed.
I'm deeply obliged.
Item 3,
Yeah, please, your lordship. Honor, we want to file additional affidavit.
Pardon me?
Pardon?
Pardon, please repeat again.
We want to file additional affidavit.
Say what?
Honor, a date may be fixed
We are not fixing a date. Once you file it, then it will be listed.
between two days.
We don't know about that. Once you file it, it will be listed. Yeah. Sure. So, please present.